All right. We are ready to start the day's proceedings. It's 13:59. Please make sure that your devices are on silent. Thank you.
Good afternoon, Ms. Hassim. Good afternoon, Mr. Premhead.
Good afternoon, Chair. Good afternoon, Commissioners.
An important housekeeping matter. I will afford each council 1 hour to argue, and I will afford you 15 minutes to reply, Mr. Premhead. So organize the flow of your argument in accordance with that. And so that should mean it's still two, it's actually two still, so I won't add anything. Up to 1,500 hours. Thank you, you may start.
Chair, I'm just putting my timer on so that I'm conscious of the time. Good afternoon to you, Chair and Commissioners. May I say that I don't intend to be as long as 1 hour. I think it will depend on the level of engagement between the Commissioners and myself as to whether we will need 1 hour. And can I say the reason I'm not going to need 1 hour is because the Commission has itself now conceded that a postponement is appropriate. The Commission has chosen a date of 14 August 2026. And that means the postponement application, which has been brought by my client in respect of his evidence for the 15th of July, rolled over to the 17th of July, rolled over to the 24th of July, is effectively unopposed.
Yeah, but the crucial issue is that the effect of what we have before us would be that Mr. Carrim never ever testifies. So that's a serious issue that needs to be dealt with.
I'm not sure I agree with that characterization, Chair, but I accept the point that you make that the postponement as to whether or not it's by a postponement to a fixed date as opposed to a postponement not to a fixed date but subject to some...
But with what we have before us, the doctor's report, the effect as we sit here now is that even on a later date to which we may postpone, we will be told the same thing.
Indeed, sir.
So ultimately the effect will exactly be what I'm saying, which is that Mr. Carrim will never ever testify.
Well, I don't know if I agree with the characterization that you'll necessarily be told the same thing, because what you'll remember from the treating doctor's report to you, and I'm not going to go into the specifics of that in light of the ruling on the in-camera issue, but what the treating doctor says is that the position of my client is dynamic and it is subject to change, and that's why one of the things that the treating doctor himself proposes is to account to the Commission under oath once every 2 weeks to update the Commission regarding the client's position and whether he can or cannot testify. It's also why the doctor's evidence under oath is to suggest that there are alternative means that can be explored.
Continue.
No?
I wanted to say, based on what we have, an educated guess would lead one to say, even though you've just made the submission that you've made, we can't hold our breath.
No, fair enough. But I was responding to the characterization that you'll necessarily be told the same thing in future. It was simply to say that that's not entirely correct.
I guess
you may be told the same thing in future, but you may not be as well.
I guess I'm saying exactly the same thing I said earlier when I say we can't really hold our...
No, indeed so. Yes. Indeed so.
Can I also just check your characterization of where and how we got here? You say the application for the postponement is not opposed. I don't see that is correct, a correct proposition. You asking for a postponement to an indefinite date, which is completely subject to what the treating medical person is going to determine whether he ever comes back and on what date he comes back. But more importantly, you are bringing an application for a deferral of Mr. Carrim's evidence to an undetermined date. That's your application, as I understand it. And the evidence leaders oppose that. And in their opposition, they say, we want him to come back on a specific date. So there is an opposition to your application.
Yes, it's a limited, that's the word they use in their correspondence of about the 23rd of July, if I'm not mistaken, where they say it's a limited opposition. And it's, if I can say this, the difference between my learned friend and myself is the mechanics of the postponement. What's not opposed is that a postponement is appropriate now. It's just subject to whether, as Commissioner Baloyi correctly says, it's an open-ended date or it's a fixed date. And that's what I was saying to the chairperson as well. So it's not to say that it's no opposition in the sense that there's no disagreement. There is disagreement, but it's on the mechanics of the postponement rather than the narrower question that I was addressing, which is that the postponement being sought today, in principle, is unopposed between the Commission and ourselves.
But if it was being opposed in the wide sense, whatever that means, the consequence would have been that if it was opposed and opposed successfully, the consequence would have been that he comes and testifies today. He's not going to, he's not here. So the distinction is a technical decision really which makes no difference whatsoever. Fact of the matter is, you are seeking his evidence to be deferred. We are here today. You say indefinitely. They say no, he's not getting the postponement that he wants. We want him to be given a date to come and appear. So I don't understand the technical differences, but at this point I wasn't engaging on the technicalities of indefinite, and I was simply saying, but this application is opposed. That's the position. Your application, as formulated by you, is being met with an opposition.
Yes, it's described as a limited opposition in paragraph 1.14 of the attorney's letter on behalf of the Commission of the 23rd of July. So that's where I was going to focus the bulk of my submissions, on the limited nature of the opposition rather than whether or not a postponement today ab initio is being opposed. I think that's where I'm directing myself, Commissioner Baloyi.
Yes, all right. But you accept it is opposed?
Yes, yes, within the confines of what I've said. Yes, absolutely so.
Thank you.
I'm not, it's like in litigation where the parties might...
Please, I think.
Okay.
Please go ahead.
No, thank you.
Continue.
I'm indebted. So by means of introduction, that's the first of the 12 points I wanted to make. The question in front of you is actually a narrower question about the mechanics of this postponement and what it ultimately looks like, whether it's to a fixed date or whether it's to an indefinite date. And what I will say to the Commission in that regard is two things. Number one, you have our submissions on paper justifying why it should be an indefinite date. But obviously the Commission, through the evidence leaders, have put up a series of considerations as to why it should be to a limited date. And practically speaking, that's something that practically speaking, that's something the commissioners will apply their minds to and make a ruling on. And all I'm going to say is that the mechanics of that ruling will be whatever it is. I'm not going to focus my submissions on the harder element, if I can call it that, which is to say it should be to an absolute indefinite date. I'm going to focus on my submissions on the appropriateness of the postponement in the circumstances in light of the evidence that you have in front of you. So that's where that's what I'm going to focus on. Can I just say that And the reason for that is because of the limited nature of this opposition, but I'm not going to repeat myself. Can I say on the second point, please, that there are two potential directives that we would ask the Commission to consider granting in respect of the proceedings today and the argument as it unfolds in front of you today, and before my learned friend has an opportunity to address you. The first one is that I'm not sure what the status of these application papers will be or become once the Commission makes its decision on the postponement. But the request is that should any part of the record become public, that it is subject to the limitations already imposed by the Chair in the in-camera ruling. So that is that the record of papers itself must not reveal or identify the very things that the Chair has said we're not allowed to say in the oral argument, because that would effectively render that ruling pointless if the paper record reveals the very things that we aren't allowed to refer to in the oral hearing. I don't think that should be controversial. That's actually asking for a logical extension of the Chair's ruling as it applies to the papers. The second directive, and this might be the more controversial one, is I know my learned friend has given me advance notice that she intends to rely on certain CCTV camera footage. I don't know if that is still the case, but there are other pieces of information that the Commission has subsequently shared with us that may also need to be treated carefully. In particular, there is mobile data geolocation information which may or may not be projected. I don't know if my learned friend intends to project it on the screen when she makes her submissions. But if she does, the point that I would request the Commission to please consider and make a directive on is some of that information contains highly specific GPS coordinates. And the reason that when it is projected onto the Commission's screen, if the Commission intends on doing that, to prevent the publication of exact GPS coordinates is because it opens the threat that the GPS coordinates, when projected onto the screen, can be used to reverse engineer exact locations. Obviously, if the CCTV footage puts my client at a Durbanville mall, I can hardly complain about that. But I'm raising a concern in respect of the facility, for example, and geolocation data near the facility. I would also humbly request that in making such a directive, when my learned friend is going to refer to or reference the suburb that the facility is located in, that the name of the suburb is not mentioned explicitly, because it doesn't take a genius to run a Google search or a ChatGPT search to ask it what medical facilities are in the particular suburb, with the effect that it gets close to the very things that the Chair has said should not be identified. So I don't know, practically speaking, when Chair will make those directives or consider them, but I think even in just flighting the fact that those are the directives I'm asking for, I'm hoping my learned friend will approach it with some degree of sensitivity, even in the absence of a directive. That's not to say my learned friend mustn't say what she wants to say or use whatever footage she does. I'm just raising the concern about certain of the information which is not necessarily expressly covered by the in-camera ruling might nonetheless be utilized to undermine the very purpose of the in-camera ruling. And that's the second request that I make. Chair, I'm in your hands as to practically whether you want me to go
for now, yes, for now, please continue with your argument. I don't want to eat into your time. What we will do, we'll raise this issue before Ms. Hassim starts arguing.
I'm indebted.
Yes. I don't think there's an issue with the
first one.
The first one, really, but we can't make rulings piecemeal. Yeah.
Yes, indeed.
Yes,
indeed.
yes,
indeed.
yes.
So that's point number 2.
Please continue.
Thank you, Chair. I'm indebted. Point number 3, now talking about the video footage. With all due respect, in light of the affidavits that have been exchanged between the respective parties, I'm going to respectfully submit that the video footage is unnecessary today. And more than being unnecessary, it's also not appropriate and does not serve a legitimate purpose. And there are three reasons why. The first one is, by and large, the allegations made by the Commission have now been admitted, answered to, and amplified by my client and the people deposing on his behalf. So the footage is not necessary because the footage is not needed to prove admitted facts. You don't need to lead the evidence to deal with admitted facts. That's point number one as to why it's inappropriate. Point number two is that the footage is an inappropriate form of evidence in light of the fact that, and you will know this because this is dealt with explicitly by my client's treating doctor, that things like video footage and geolocation footage or geolocation information and so on does not have clinical value.
Sorry, what noun did you use? It's inappropriate what? It's inappropriate? After inappropriate, what's the noun you used?
Oh, inappropriate form
Okay.
of evidence.
Oh, all right, thank you.
Inappropriate form of evidence because ultimately what underlies the Commission's concern and the Commission's complaint regarding my client's postponement is a medical issue. And so this geodata information or CCTV footage or whatever it is, on its own, not being led through a clinician, and not being analyzed by a clinician or responded to by a clinician is inappropriate secondary evidence, which is being used to gainsay the medical opinion expressed about that exact approach.
Are you talking about Durbanville? Or
Yes, Durbanville.
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 Can you please explain your point about it relating to what may have to be attended to by a medical practitioner?
Yes. May I just ask Ms. Matlingwane for some...
Because let me tell you why I'm asking you this. I see it as objective material which says he was there.
Yes.
So I don't see the connection with what a medical practitioner might have to say on the issue.
May I respond?
Yes,
Give two
yes.
responses. The
Yes,
first response is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact between the parties. There's no need to lead the evidence. But the secondary line of reasoning, and this is where I need Ms. Matlingwane's assistance, but she'll hear me in response to you, Commissioner. I'll give you the reference after the fact, is this. The medical practitioner says that the Commission relies on a bunch of evidence, such as CCTV footage, Apple Pay data regarding payment accounts, movement data gleaned through geolocation data. And the position of the clinician, for reasons that you know which are recorded on the papers, is all that demonstrates is movement of some kind, but that the movement of some kind, the fact of the existence of the movement of some kind, is of no value in determining the clinical issue as to why the client cannot attend or attend the Commission to give evidence. So the point as to inappropriate is that it doesn't deal squarely, with all due respect, with that clinical issue, and particularly in circumstances where the clinician has raised doubt about why it's being used in the manner in it's being used.
I get you on your first point, which is why flight that footage if there is no dispute about his location on the day and at the time. I get your point. I'm not sure that, one, you need the second point, and two, I am not subject to whatever else you may say. I'm not convinced by your second point. But please continue. But I stress that you don't, in the face of your first point, I'm not altogether sure that you need the second point.
That's where, that's...
On this issue, it's a very weak point.
I think we're ad idem on the first point, and what I would say is that if those facts are not in dispute, then needing to flight the footage so as to prove something that's not in dispute is unnecessary. And
you see, your second point would make sense if the flighting would be for the purpose of showing that by being there, the medical condition relied on simply does not exist. If that was the purpose, I would understand your point.
Yes.
I'm not necessarily saying that Ms. Hassim is not going to argue that.
Yes.
I do not know what she's going to argue. But perhaps until she has argued that point, as I say, from where I'm sitting, I don't think you need the second point, and I repeat, I think it's a weak point for purposes of this should not be flighted.
well, let me accept the invitation then to simply say, if my learned friend, well, I'm caught between a rock and a hard place, because during my learned friend's submissions, she may flight the exact footage to make the exact point that Chair is putting to me, which is because he was at X place, that brings into doubt the medical evidence. And in fact, that is the Commission's case, because in their affidavit, they call my client, with all due respect, gratuitously an inverse outpatient. So the very attitude of the Commission, through the evidence leaders, is not to say that, oh, this is a benign piece of evidence, the CCTV footage. The entire thesis underlying their opposition to the postponement and why they want to tie down my client to a specific date is to say the fact of these movements, the fact of these payments, the fact of that he's not in the hospital all the time brings into doubt the medical diagnosis that the clinician has given him, and that's the further reason as to why we need an independent medical exam. So may I just finish on this, please, Chair?
By all means.
If my learned friend is not going to push that line of argument today in front of you, then I don't need the second point. But if my learned friend is going to push that point, then I do need the second point, even if Chair says he's not convinced that it's a strong one.
You see, just to make sure that I will not be misunderstood, the question whether Mr. Carrim's movements show a pattern that is at odds with what we have been told, that's central to the evidence leader's case. So what I said earlier did not suggest that Ms. Hassim is likely not to argue such a case.
Agreed.
But I'm making a different point. That case can be argued without the need to actually flight the footage.
Agreed.
Why not? Exactly because it's agreed that at the time, on the day, Mr. Carrim was at a shopping complex in Durbanville.
Agreed.
So that point can still be made, or that argument can still, but as I said, whether Ms. Hassim will actually want to flight the footage, we'll hear her when she says so.
Indeed.
Yeah. Shouldn't we leave it there and move on,
yes,
please?
I'm happy to. Can I just give you one reference, if I may?
Yes.
If you look at paginated page 94 of your pleadings bundle in the postponement, paginated page 94, you'll see the heading, it's geolocation data and its clinical significance. The basis for the submission that I was making to you comes from paragraph 45 on that page, as to why flighting that is unnecessary over and above the reason that Chair has already identified that it's not in dispute. So I'll just leave that, if I may. What Ms. Madlanga is doing is she's looking through the Commission's papers to give me the reference, the exact reference of where this debate arises from in the way that Chair posits it to me. So Ms. Madlanga will give me that reference shortly. Can I also just say this? This moves me on to point number 4. 23 minutes in. Point number 4 is this, is that the medical evidence in front of you from Mr. Carrim's treating clinician is undisputed on the clinical diagnosis and the clinical observations that Mr. Carrim's treating medical professional makes. There is an expert report, and I'm not even going to mention the expert's name, put up by the Commission, which generously doesn't actually dispute that clinical observation. What it does is it speaks to 2 collateral issues. The first one, which with the greatest of respect to the expert is an invention of his own, is he talks about it being inappropriate for Mr. Carrim's physician, Mr. Carrim's medical practitioner, to perform what is called an independent medical exam on Mr. Carrim. It's referred to in the document as an IME. The simple point about that IME and why then it can't be used as a basis to impugn Mr. Carrim's medical doctor's clinical observations is Mr. Carrim's medical doctor never performed an IME. An IME is an entirely separate form of medical examination that is performed in a forensic context where there needs to be, understandably, a degree of separation or independence between the medical examiner and the ultimate patient. But in this particular instance,
how do you describe forensic in this context?
when you say in this context...
Or rather, let me leave out in this context.
Let's say, like, Chair, this goes back to that discussion you and I had the last time. If we were in Uniform Rule 36 territory, and you'll remember you and I had the discussion about Uniform Rule 36 as a parallel mechanism through which examinations occur in instances of medical negligence claims. That's the forensic parallel that I would say the IME concern arises in.
I would understand the rule to be the vehicle in terms of which you get to the whatever it is the medical practitioner has to do.
Yes.
That doesn't necessarily answer my question, I don't think.
Well, the difficulty in answering the question is that I'm trying to distinguish what the Commission's expert report criticizes Mr. Carrim's medical practitioner for allegedly doing and why it's inappropriate. And I'm responding...
Let's take, for example, the context of criminal proceedings where the rule you are referring to would not apply at all. I would imagine that even in that context, you can talk forensic. When medical practitioners are involved.
Yes.
So it's on that basis that I'm saying, how would you describe or define forensic in a way that, for example, would exclude what we have been given here? Why is it not forensic here?
And that's the exact criticism that the Commission's expert attempts to make, is that the Commission's expert, as we understand it, says that the treatment Mr. Carrim is receiving can never be an IME exercise because he's not, in inverted commas, independent enough of Mr. Carrim. And the point I'm making is that's exactly correct, because the treating doctor is not performing an IME for some forensic, independent, objective, evaluative purpose, like under a Section 79 inquiry or under a Rule 36 type inquiry. He is the patient's, Mr. Carrim's, own treating doctor. So he doesn't, the point I'm simply making is that the basis upon which the Commission's expert, it seems to undermine the clinical evidence in front of you from that doctor is to say he's not entitled to perform an IME and what he's given you is not an IME. And we're agreeing with that because we're saying the treating doctor is doing something fundamentally different. So that's the first point that I was making.
Please continue.
The second point that I was making, to the extent that that report is relevant in front of you, is that that report itself emphasizes the role to be played by Mr. Carrim's own treating doctors before any such directive can be given that he's subject to the medical examination of another. And you can find that at Annexure MT1 at paragraphs 18 to 19. And it's also referred to in the evidence leaders' submissions at paragraph 47. So the very point is to say that the medical evidence of Mr. Carrim's doctor is unchallenged directly. To the extent it is challenged, it starts from an incorrect premise. But even if it does start from the correct premise, it emphasizes the very point as to the centrality of Mr. Carrim's own treating doctor and Mr. Carrim's treating doctor's clinical observations as it influences any future process. And you know Mr. Carrim's treating doctor's clinical view speaks to Mr. Carrim's non-ability to give evidence. And I'm using ability deliberately because that obfuscates what is known to us but not to the world at large. So even that report ultimately draws a point to say that the medical doctor's observations who's treating Mr. Carrim have a central role to play in any determination in how Mr. Carrim is treated. And we would say that the evidence speaks for itself and it's unchallenged in front of you. But there are a few more things I'd just like to say in that regard, if I may. The first one is, our learned friends provided us a bundle of authorities. A lot of it is foreign authorities.
Before you go to authorities.
Yes, Chair.
I think the first point that doctor makes, that is Mr. Carrim's, is that, and I'm going to an assessment by an independent doctor. So Mr. Carrim's doctor says such an assessment, in fact, I think the doctor uses the word interpositioning. So if another doctor is interposed, that will be deleterious to the treatment that Mr. Carrim is undergoing.
Correct.
So the first point or the first prize is that no other doctor should be interposed. But as I understand it, your expression seems to suggest that I'm misunderstanding the situation. But let me continue. You will respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
I know. Then the second point, as I understand it, is that if, despite my opposition as the doctor, as the treating doctor, if despite that the position is that another doctor should be interposed, that should be done in, I'm paraphrasing here, forgotten the actual wording, that should be done in consultation with me. I should be involved. As to how exactly, I'm not altogether sure now, should be done in consultation with me. Now, what I wanted to raise is, if the doctor does say that as an alternative, would Mr. Carrim oppose this? That is the alternative. Would Mr. Carrim totally oppose it?
Well, I have no instructions on that, and as you know, the legal team have had to obtain instructions.
No, in the manner in which you and I know, yes, how this is.
So I would have to take an instruction, but if I may, I don't know if you are done, Chair, and I don't want to interrupt you.
Yes,
but
yes.
Having regard to my facial expression earlier, the reason that it was of that kind is, if you can go to the paginated pleadings, please, paginated page 49.
Yes.
If you look at the heading just above paragraph 68, the consequence of compelled attendance. So I think how I understand the treating doctor's position is this. And I think, Chair, this goes back to the debate you and I had last time, and can you draw any inference from a compelled attendance where it's chosen not to attend or a voluntary attendance. The position of the doctor is that it's not to say that none should be interposed as a blanket position. It's to say none can be interposed unilaterally or in a compelled sense that the doctor resists. And then the doctor's position in respect of what then, so in other words, if it's voluntary, does it come through me, or whatever the case might be, is expressly dealt with in that same affidavit at, I see Ms. Madlanga is marking paginated page 51. For example, he doesn't deal with it in express terms, but he's talking about in paragraph 71 on page 51, he's talking about less intrusive formats of engagement and his ability to manage the downstream consequences of the format ultimately chosen as a consequence of what the Commission chooses to do or not do. This paragraph admittedly is talking about, in part, the in-camera question, should it be open or should it be closed? But it's an answer to you, Chair, about the extent to which the doctor's position is not to say, you know, I am the block, so to speak, and if I say no, it's no. The doctor's position is to say that I must be consulted, and if I can facilitate something which is not clinically detrimental to my client's, my patient's current position or future position, then I would have to give medical advice in that regard. So it's to say that it's not perhaps as blunt as the way in which the Chair was positing it to me.
Now, exactly on what you said last, my question relates exactly to that. If in a sense, even if qualified, the doctor is not altogether rejecting the idea of interposing another doctor, what would Mr. Carrim's position be? And that, I think that's the point on which you already said you have no instructions.
Yes.
Okay. If we were to say, please get instructions, by when would we get a response on that?
I can't commit because it would have to be relayed to the two individuals who would then have to engage with Mr. Carrim when he's available and then have to come back to us as the legal team. As you know, one of the issues is that in present circumstances, we don't have direct access.
But I would imagine, on my understanding of the protocol, the existing protocol, surely there must have been a good few interactions following that protocol. I would imagine that should give you an idea of possible time frames.
No, because in as much as I thought advocates were busy and have busy diaries, I've never dealt with medical professionals whose diaries are even more challenging than ours. And that's why, for example, some of our papers reached late because of when we could consult with the medical professional in particular concerned. Can I say this? In principle, on what's in front of you and what the doctor himself has said, there should be no objection. But that's obviously subject to his ability to speak on behalf of Mr. Carrim with or without Mr. Carrim's consent. Whilst maybe my learned friend is on her feet, so to speak, proverbially, maybe what I can ask is Mr. Bismillah, who's sitting behind me and from my instructing firm of attorneys, can try and get in touch with our other attorneys and the relevant individuals to try and take a specific instruction on what Chair has put to me. That's the best I can offer in the circumstances.
Yes. I must make the comment that what you've just said now is quite useful, which is that there is no in principle objection to the idea.
Well, because from my reading of what the doctor has said, is his opposition, in inverted commas, was on the unilateral imposition of a third-party medical practitioner. But the doctor has himself spoken about less intrusive means in a multitude of manifestations. And if the doctor interposing in respect of a third party to obtain voluntary consent, whether it's given or not given, is within the basket of those less intrusive means, as I see it, because it's not the compelled examination. And so that's why I say, in principle, I don't understand that could be an issue, but I will ask Mr. Bismillah to get the specific instruction.
Thank you. Please continue. Are you moving on to another point?
I see Commissioner Baloyi.
Yeah, before you move on, let me just clarify. You and the Chair seem to be of a common understanding of what the doctor is saying. So it may be I misunderstand. I'm looking at reading from 73.1 up to 73.3. I understand the doctor to say that there must first be engagement with him on these medical issues. And if we are not happy, and I'm reading now at paragraph 73.2, what is clinically objectionable.
May I ask for the page, please, Commissioner?
Sorry, 52.
Thank you, 52.
Commissioner. 73.1 up to 73.3, but the clarification that I would like to have is because of what he said in 73.3. He says a properly constituted assessment stands in a different footing. If after engaging me, the Commission remains unsatisfied, I do not object in principle. So on the doctor's offer, he anticipates he's given a report, then he must be engaged with about his report by the Commission. And if we land at not being satisfied out of our engagement with him arising from his report, then he does not have an objection to the interposition subject to whatever he says there. I understand you and the Chairperson to have formulated it as follows: that as matters stand, the doctor does not have an objection to an interposition, provided there's a condition, the conditions in there met. Am I misunderstanding?
No, we were past the original stage, which is about the conditionalities. I was on what I referred to as a fallback position, as it were, and I don't think it differs from what you've just said.
See.
Yeah.
I think we're all at idem because Commissioner Baloyi, you looked at 73.
I think Commissioner Baloyi has just said yes.
Oh.
When I made I think you should move on to another point if you are about to.
Okay.
I don't want you in the end to say the hour was too short because of our engagement.
Yes. Could I, all I'll say to Commissioner Baloyi, if I may, is I know, Commissioner, you looked at 73.3. When, you probably have looked at it already, but the way in which I would look at what he's saying in 73.3 follows on particularly 73.1 and 73.2 on the same page. But as it relates to that earlier statement, which is where the chair and I started about a compelled examination. And I think what he's addressing in those circumstances is what the deleterious effect of a compelled imposition of a third-party medical practitioner would be for what he is doing, but not to say that that's a total out-ruling of less intrusive means, provided that whatever the less intrusive means are, plays a suitably respectful role of him as the treating doctor, which I said at the very beginning, even the Commission's own expert accepts that that's the role to be played by his treating doctor.
Okay, I understand. Thank you.
Thank you, Commissioner Baloyi. Just so that I was making the point about the authorities, and I now see it's 44 minutes, I'll be quick.
And I took only 3 minutes at that time, please.
Don't worry, I'm not going to ask for an accounting exercise between the commissioners and myself, but very quickly, if I may, the point about unchallenged medical evidence and proceeding in the face of unchallenged medical evidence. And you know, I say that my client's doctor's evidence, when properly understood, is unchallenged. That point is made by the same authorities relied on by our learned friends. So, for example, at paragraph 16 of the Hyatt case, which can be found at pages 6 and 7 of their authority bundles, that point is made. That point is also made again later on in that paragraph, in that judgment at paragraph 32B on page 12. And interestingly, it says it would be wrong for a committee which has the livelihood and reputation of a professional individual in the palms of its hands to go with a hearing where there is unchallenged medical evidence that the individual is simply not able, and I'm using the word able to not use the word in the quotation, to withstand the rigors of the disciplinary process. And why I emphasize that is because you know the position taken by my client is that the secondary evidence, the CCTV footage, the geolocation data, even their own doctor's report, doesn't challenge the medical evidence properly in the way that the medical evidence is in front of you.
I'm not sure that that's a good point because I think at the last appearance, you strongly oppose any idea of an assessment by an independent doctor. So on that basis, there can be no question of us having a report by a doctor challenging what Mr. Carrim's doctor says. So we all understand why there is no opposition.
No, with all
it's not as if with an opportunity available for another doctor to counter this doctor's report, no counter was furnished. It's on that basis that I feel that's not a strong point at all.
I respectfully disagree with you, Chair, in the following two respects. On the last occasion, it was not that I had any objection to an independent exam being performed. It was whether or not it could be compelled and whether or not any inference could be drawn.
That boils down basically to the same thing, because in expressing your view that compulsion was not possible, the upshot of that was that you were opposing. That was opposition. And you even, that was the context in which you referred to the rule in the context of civil proceedings. You said, you questioned our power.
Correct.
Our legal power to even compel.
Correct.
That's opposition. So
Yes.
I don't understand.
But then
your
you
point
and I
here.
landed on the agreement that no adverse inference could be drawn if it's a voluntary process.
That's something else.
No, but that's the
something
point
else.
I'm making. The point I'm making is my opposition, so to speak, at that time, in the way in which we understood the Commission's case, was on the issue of the compelled examination. What I'm saying in response to this issue as a continuation of what just happened between yourself, Chair Commissioner Baloyi, and myself as well, is that if the voluntary examination is the mechanism, with the interposition of Mr. Carrim's own doctor or not, then that would be fine, because that also means that no adverse inference can be drawn if he declines to not participate in that. That's where we landed the last time.
No, you never. I accept that today you have made the point that in principle there is no objection to this happening, but that's subject to instructions being, or rather your instructing attaining, finding out what the position will be in terms of an acceptance or otherwise of the assessment. You are saying something like that for the first time now. On the previous occasion, you strongly argued against it, making the point that we simply do not have the power. And you distinguish the fact that we do not have the power by making reference to the power that a high court has in civil proceedings in terms of the rules. At no stage did you ever get to a point that said, no, we are amenable we are voluntarily amenable to an assessment by another doctor. You never got to that point.
Because the debate didn't get that far, with due respect. Where we ended, and we were having a general conversation, is that I ultimately accepted that if it were a voluntary process and that no adverse inference could be drawn as to the participation in that voluntary process, that's where we left it.
But Mr. Premier, did you, because more than one letter, in fact, at least two that I remember from reading these papers for this postponement application, more than one letter was written to Mr. Carrim's attorneys requesting him to avail himself for an assessment by an independent doctor. Initially, there was no response. And was there a response the second time around? I'm not sure. But here, in open session in this commission, what we got was the vehement argument by you against that as a possibility. That's all that we know. So for you to suggest that, however, there could have been the possibility of a voluntarily agreed to assessment comes as a complete surprise to me, because the attitude throughout, especially in the face of the two letters that were specifically asking for this assessment, what you say now simply does not accord with that history. That history culminating in your argument before us here. If Mr. Carrim was prepared at all to subject himself to the assessment, we should by now have received something from him or his attorneys saying that here I am willing to subject myself to that assessment that the Commission's attorneys have asked for more than once. So I don't understand your argument. Insofar as it relates to the possibility of Mr. Carrim subjecting himself to the assessment voluntarily, I do not understand that part of your, not in the face of the history I'm referring to.
No, I accept that, and I'm not going to try and relitigate that history now. I think I'm going to go and read the transcript, because at this stage, I'm going to respectfully say recollections may vary, and then I can come back to you and reply and clarify that as needed, because as I say, I remember the debate having happened slightly differently, and it was on the characterization issue about voluntary or compelled, and it didn't go beyond specifics about what if it's voluntary, then what is the instruction in the way that it was put to me today. And in light of the new evidence that has come about less intrusive means, that's why I gave an in-principle answer subject to my instructions. But I'll read the transcript and I will come back, and if I'm wrong about that, then obviously I will be wrong and I will apologize to the Commission accordingly. But if I can move on.
Just to protect myself from a full-on egg on my face, let me say I'm also only human and fallible, so my memory may also be inaccurate. Please continue.
Yeah, well, that's why they have appeal courts. They can correct the lower court judge's memory. But no, Judge, thank you. I accept that. Let me just say this. The other mechanism available is that there could have been, in terms of direct challenge to Mr. Carrim's doctor's evidence, is that instead of the report that was put up, which talks about a subsequent process, which is I'm going to describe as collateral, a rebuttal witness could have been brought. And the rebuttal witness, like ordinarily happens in civil litigation where there are contesting expert witnesses, which doesn't necessarily involve an inspection in loco per se of the incident or the person, is possible, and that wasn't done either. You've already heard me. I was going to take you through the authorities, but I don't think that that's necessary for me to do so, except to refer to one judgment, if I may, which is one that's cited, I think, by both of us. It's a South African judgment. It's Michael versus Linksfield Park, 2001, Volume 3, SA 1188, SCA, at paragraph 39 in particular. I just gently point out that there the SCA said, the assessment of medical risks and benefits is a matter of clinical judgment which the court would not normally be able to make without expert evidence. And so that's the point that I'm making. Insofar as there's direct medical expert evidence in front of you is concerned, there is no rebuttal of that. It remains unchallenged, and the Commission should be slow to draw any inferences from alternative sources of evidence as to what clinical value it has or it doesn't have. Because that alternative evidence is not clinical evidence, and with all due respect, you don't have a duly qualified clinician in front of you who offers an alternative view about Mr. Carrim's clinician's view of Mr. Carrim. In fact, the expert report put up by the Commission itself expressly qualifies itself by saying, I don't offer an opinion on the underlying medical assessment made by that clinician. So, insofar as the clash of evidence and the weight to be attached to the evidence is concerned, in the exercise of your discretion as to whether a postponement should be granted, I come back to the point that the stronger evidence is Mr. Carrim's clinician's direct evidence and not all these alternative sources of evidence that the Commission may rely upon. You've already heard me on the issue of the electronic data cannot answer the medical question. I've made that point a few times. I don't think I'm going to go there unless the Commission wants me to. You've got that in front of you. All I would say, and having read the papers this morning again, as well as the correspondence, you also know that there's I'm going to use the word challenge, but I'm going to say it's in inverted commas. There's a challenge to some of the evidence in front of you, how it was obtained, but more than just simply how it was obtained, whether it's reliable because of identified instances of errors in that evidence. I don't think that you necessarily have to make a ruling or determination on that today. It's simply to say that in the assessment of the evidence is concerned, you've got questions about at least reliability, and to the extent that any weight is going to be placed on that, you should place less weight on that than you should the direct medical evidence in front of you. Could I then just make progress in the 3 minutes I have available? I think we've already foreshadowed the debate about my sixth point, which is about the 14th of August versus some open-ended date. the Commission heard right up front, I said that that would be a judgment made by the Commission as to how it fixes it or doesn't fix it, having regard to the medical evidence in front of you. I'm not going to deal with that further. May I just say then, on this issue of the the independent assessment, I think we've debated that extensively already. It turns on the characterization of whether it's voluntary or not voluntary, and it also turns on whether it's facilitated or not facilitated. And there's consensus between Mr. Carrim's treating doctor. If you read paragraphs 90 to 94 of the paginated pleadings, I don't need you to go there, I'll just give you a note. Paragraphs 90 to 94 at record pages 53 to 54, and this is also the sequence that the Commission's own expert agrees with. And if you look at paragraphs 18 to 19 of Annexure MT1, I think I've given you that already, you'll see that there's a synergy between that. So if any direction is made regarding Mr. Carrim and any voluntary medical examination, we would ask that the chair takes into consideration the involvement of Mr. Carrim's treating clinician. We also know that there's a threat of a referral for prosecution if Mr. Carrim does not appear again, whether advised or not advised, to not appear based on his medical condition. All I'll say in that regard is if the Commission feels, and when I say Commission, I mean the evidence leaders through the Secretary, or is it through the chairperson, through the secretary, feels that an offence has been committed and that a referral for prosecution must be made, then the evidence leaders must do what they deem appropriate, and Mr. Carrim will also do what he deems appropriate, including leading evidence, whether at a pre-prosecution decision stage in front of the NDPP or at a post-prosecution decision stage in court, that he was medically and legally advised throughout, and that any prosecution will fail because there's an absence of willfulness, and that will be demonstrated on the evidence. But I don't think you have to worry about that so much. That's out of your hands once any such recommendation would be made. I'd also just point out, and I'm trying to sweep now in the 15 seconds I have left, I just want to point out three interrelated propositions, if I may. The first one is that you will know on the last occasion, not when my learned friend Ms. Hassam was here, but when my learned friend Mr. Chaskelson, who's not in his usual place today, was here, there was some debate between whether or not, if Mr. Carrim doesn't appear in front of the Commission again, and Chair, this takes us back to our recollections may vary, because what I seem to remember is after you and I had that discussion about voluntary versus compelled, the discussion then moved to what are the inferences that can be drawn in the ordinary course about the so-called unanswered questions that Mr. Carrim would not have answered by the end of this process if he never comes to the Commission again. I see the Chair is nodding, so at least I'm remembering that correctly, I think. But the point that I would make is that that time, and in its letter of the 24th of June, the Commission's evidence leaders were emphatic that if Mr. Carrim doesn't come again, they're not going to entertain this business about a postponement or no postponement. They were going to ask the Commission to make conclusions, or even on an inferential basis, on the basis of those unanswered pieces of evidence, and if necessary to make a recommendation. And all I would point out is that the sudden change in now seeking to compel Mr. Carrim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Carrim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush in the sense that not the entire case is sought to be answered is made clearly for Mr. Carrim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier, and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits, because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered that were supplemented by Commissioner Khumalo. It's the same complaint, with all due respect, that we shouldn't be drip-fed information. We should know what the Commission has in mind so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Carrim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just take you to page 24.
I'm there.
Yes. Please read paragraph 67.2. And after that, 67.3.
Yes.
And also go to 71. Read 71. I'm not reading these because...
I understand, Mike.
Chair,
yes.
sorry to interrupt, but what page are you referring to?
25.
I said 24 initially, and then it's 24, page 24 was the first reference.
67.2.
Paragraph 67.2. And then 67.3. And then I was moving on to the next page, 25, paragraph 71. Now, I want to ask a question that relates to the information that has been asked for repeatedly, which is the name or names of the auditors/accountants of Mr. Carrim's companies. That's number one. Number two, the financial statements of those companies. That information was asked for a long time ago, I think in March already. I think initially when Mr. Carrim was testifying here on the 8th and 9th of March, I think, and he promised or undertook to furnish that information. In fact, I think in respect of the auditors, he furnished a name of an entity that eventually denied that it was auditing any of his companies. But subsequent to that, that is the oral undertaking in open session, there has been engagement on that issue, and Mr. Chaskelson has repeatedly made the point about this information continuing to be outstanding and not being furnished. So it's something that's been out there in all of our minds. Now, I refer you to these 3 paragraphs to make the point that, one, the person mentioned in 67.2 is Mr. Carrim's PA. And she's even described as his quote-unquote virtual PA. Quite importantly, here's what is said about her. It is said that when Mr. Carrim's bank account or bank accounts, I'm not sure whether it was more than one, was aware in the process of being closed by F&B, this virtual PA played a very crucial role in that process. So it seems to me that this is someone who is closely involved in Mr. Carrim's affairs. Now, the other person mentioned in the other paragraphs is someone very close to Mr. Hassim and someone who has in his...
Mr. Carrim. Not Mr. Hassim.
Oh, I'm so sorry. I'm sorry, Mr. Hassim. And it's someone very close to Mr. Carrim and someone who has been appointed to run Mr. Carrim's businesses in his absence. Now, if you look at, which paragraph is it now? Let me see. Yeah, I think it's 20, something. Content of 25 about her. Oh gosh. I've lost my place now, but you will all know what I'm referring to. I just have page 25 now. I would imagine. I doubt that it's there, but maybe it is. But the point is this. The deponent to Mr. Carrim's affidavit, the founding affidavit says, I do not know the auditors of Mr. Carrim's affidavits. I think I can mention that it's his wife. What the ruling says should not be mentioned are the names, I think, and other identifying features.
He also has 2, so...
One of the wives is the deponent. Thank you. So that's the wife. She says, I do not know. And she says, nobody else knows. So this means the virtual PA, who I assume that as a PA, she must be working very closely with Mr. Carrim. And the fact that she even assisted very closely when the bank account or bank accounts were being closed shows the proximity. I do not see the basis on which Mr. Carrim, with regard to who the auditors are, would have been cagey about that information. Not to the PA. I do not see how he would have been. Also, I may not be able, because I do not know the historical involvement of the person now running the businesses prior to him doing so after appointment. I do not know his historical involvement in the companies. But point is, once involved, what would be so difficult in him getting information with regard to these 2 issues, who the accountants are, and even getting copies of the financial statements? Just what would the difficulty be? Also, this person who's now running the businesses is not the only person. There are other people who have been in place working in those companies. That information cannot reside in Mr. Carrim's head only. I find that very, very difficult to understand. In fact, I want to say this or suggest this to you, Mr. Pramit. You probably are aware of the Gauteng High Court judgment in the case of truth verification. If I'm not mistaken, I think it was written by an EL of AJ, not the old Friggy EL of JP. And the principle enunciated in that case was later made or adopted by the Supreme Court of Appeal. But the point is this, and perhaps let me clarify up front, that that principle relates to respondents who make fanciful or patently false statements on affidavit. And that authority, jurisprudential authority, exists because on paper where you do not test the testimony of witnesses in a witness box, it's very difficult for courts to say that person is not telling the truth. But the usefulness of this authority is this. It says, if what a witness says is either fanciful or patently false, it should be rejected out of hand and on paper without the need for oral testimony. So even if, as I say, this principle has been used in respect of respondents, I do not see why it cannot apply to applicants as well. Where am I going with this? I feel as I sit here, subject to what you say, that the idea that nobody within these companies, in particular the person now running the businesses and this PA, nobody can furnish this information. Nobody knows anything about this information. Subject to what you say, to my mind, this appears to be patently false. Your comment?
Natal Scrap Metal and Oxford University Press also endorsed that proposition.
Yes.
On consideration of the Plascon-Evans test. So I don't know if those were the SCA authorities you had.
That would have been a movement or a development on the Plascon-Evans.
No, but I know the proposition that you're making.
Yes.
Can I direct your attention to paginated page 74, particularly paragraph 40.1, as it relates to I'm using this word in inverted commas, an inference that is perhaps being made about the role and level and intensity of the EA or PA or whatever she's called, and the extent to which they might have business knowledge. And the starting point was, and Chair quoted it, was her involvement when the banking accounts were being closed and so on. With all due respect, I would suggest that 40.1 attenuates that because it speaks to the very limited and I'm going to say rubber stamp, and you'll understand why when you see that paragraph, that rubber stamp manner in which she acted. So I'm not sure, with all due respect, in terms of what is in front of you on the evidence, that she does as intensive a role as perhaps Chair was suggesting. Obviously, Chair will draw his own conclusions.
She open quote, managed the replacement, close quote. That's an advised or conscious choice of word.
Yes, and then look at line
managed.
But look at line 3, how she managed it and that process. She had access to and used an electronic signature during that process. So the point is that her involvement, and I'm speaking carefully because I'm not giving evidence.
I'm not sure that the third line suggests that all that she did was to sign electronically. I'm not sure about that. I believe in context that that's mentioned as as part of the things that she did, she signed. It doesn't suggest on my reading that all that she ever did was merely to sign electronically. That's not how I read this. She managed. Otherwise, manage would be meaningless if all that she did was just to sign.
I accept what you say, but I would also then ask you to go back to 67.2 on page 24, because if you look at who she works for, it's not Mr. Carrim himself, it's the wife. That's stated in that paragraph in the first sentence. And then you'll see what she does is, all she does is she screens my husband's calls and emails, liaises with the banks, including in relation to the closure and the replacement accounts, facilitates payments.
Sorry, page?
24?
20.
The paragraph 67.2 that you took me to, Chair, at the beginning.
67.2.
Yes, point two. So I was just saying that the first sentence contextualizes who she's actually working for. It's the wife, not Mr. Carrim per se. And then in the second sentence, you'll see what her activities involve. And her activities are described as screening husband's calls and emails, liaises with banks, including in relation to the account, and we've gone to that page already, facilitates payment of staff and directs matters requiring attention to the appropriate person. So I accept Chair reads that in a different way to I do, because Chair says that's indicative of a more central role that perhaps suggests she could provide these answers or whatever the case is.
Yes,
I don't read it.
I do not see after, towards the end of the paragraph, what you've just read. I do not see how her role can be diminished, not with all of the things that are itemized there as her duties. I do not see how her role can be diminished.
I accept what Chair puts to be. I'd say it can be diminished because it's not a decision maker qua decision maker. It's clearly that she plays a supportive role. And so she doesn't have this as expansive ability as Chair is perhaps suggesting to do the kinds of things that Chair is speaking about. So that's the first thing I would say in respect to that individual. The other page I would ask Chair to look at, and I had it a second ago if you'll bear with me, is paginated page 351. And all I point out is paragraphs 51.1 and 51.2, particularly the last sentence on 51.2 on paginated page 351, because that in part speaks to Mr. Carrim and the ability to obtain that information, and why even what has transpired before transpired in the way that it did. Insofar as the other individual which Chair mentioned, which is back at page 24, paragraph 67.3, if I'm not mistaken.
I think, was it not also 71?
Yes, no, 71 as well. That was on page. That was on page 25.
I meant paragraph, not page. Paragraph 71.
Paragraph 71, page 25.
Oh,
which speaks to the same individual that is mentioned in 67.3.
Okay, yeah.
Yes. Again, all I would say regarding this expansive role that he's playing or he's not playing is look at the fifth line in that paragraph 67.3, starting with he does not make. And I would say that that sentence is a direct answer to the Chair regarding what he knows or doesn't know or couldn't know. in particular that...
Mr. Premier, providing information has nothing to do with making strategic decisions
Yes.
and new business decisions. It's historical information.
Yes, indeed, which is why the sentence I was going to direct you to, Commissioner Khumalo, reads in terms, given his age, he does not possess the institutional knowledge of the businesses that resides with my husband. So even if you're interpreting that first sentence against me about providing information not being strategic decision-making, which I can accept, the second sentence in particular speaks in terms to his ability to provide the information or otherwise. If you reject the explanation on paper, that's what you'll do, but that's the evidence you have in front of you. So also insofar as the same individual is named at paragraph 71, page 25 is concerned, you have to read those two things consistently with all due respect, which says that the individual concerned is doing nothing other than acting in a holding pattern or in a holding capacity, but doesn't have the institutional knowledge going backwards and also doesn't have the strategic insight and knowledge going forwards. But I accept, Commissioner Khumalo, that might be an unsatisfactory explanation.
You have not answered the second part of my issue, which was, how can it be that within these institutions, all of them, there is not a single person who knows something about the accountants or auditors? How can that be? How can that be? How is it that this information resides only in Mr. Carrim's head?
I want to choose my words carefully because I'm not going to give evidence as to why that is or isn't the case. But I think it was Commissioner Baloyi, you'll forgive me, on a previous occasion when Mr. Carrim was testifying, there was a debate between Commissioner Baloyi and Mr. Carrim about how particular decisions are made or not made, and are there proper books of account, and what's the regularity of what's going on inside this business from a corporate perspective. And Mr. Carrim at that time did not say much other than to say how it appears in front of you is what it is. And without putting words in his mouth, all I will say is that businesses operate how businesses operate. They sometimes operate imperfectly. They sometimes operate less elegantly than they should operate. Whatever inference you want to draw from that, you will obviously draw, but the fact that it's not so elegant and bookkeeping or company board resolutions are not maintained in the way that the Companies Act wants them to be maintained is the very basis that most of us have a job as lawyers, because these things happen in the real world in the way that they happen. So I can't answer with a positive version as to what the chair puts to me, which is how is it that it can only be one or should there be others? I have no instructions in that regard, but having regard to what has previously occurred, where Mr. Carrim was put under some pressure, and I say that respectfully, put under some pressure to account for his business operations, which appeared to be less than perfect. He himself couldn't address that in any great detail other than to say that the businesses were and are what they are. And that's as far as I can take it, Chair. I mean, yeah, I'll leave it there.
Can you please assist me? I wrote only paragraph numbers of the doctor's report. Where does it start? Please assist me. I want to take you somewhere there.
Sorry, Chair, can I ask for a clarity? Is it one of the doctor's reports or the affidavits?
The affidavit, the very first one, not the supplement.
Paginated page 30, Chair.
30. Thank you, Mr. Premier. Oh gosh, how could I not have, because I can't read this again, nor can I describe it because it will
Paragraph
go
number,
to the
Chair.
wrong terrain. Let me just see. Okay. Oh gosh, I'm sorry, I did not underline this. But I seriously want to engage you on this. I can't vocalize the point, otherwise it will, can we take a 2-3 minute adjournment? Please, I want to vocalize this outside.
Okay.
Let's adjourn. think an explanation is owed to the public. This was not turning what I ruled would be an open session into an in-camera session. No. The reason for going out is that everybody will recall that earlier I asked on a totally different point or issue. I asked Mr. Premhead to read certain paragraphs for himself, and then I put questions to him. The reason for doing so was to avoid divulging the sort of information that I said, or in my ruling, should not be divulged. So that's why those paragraphs were not read publicly. Now, this time around, I wanted to do the same thing, that is refer Mr. Premhead to a paragraph for him to read for himself. The reasons were exactly the same. The problem this time around was that I did not find my correct note which directed me to the paragraph, and I was only able to find it once we were outside. So Mr. Premhead, I believe, has now already read the paragraphs. Now, here's my question, Mr. Premhead, and it relates to both paragraphs. Why is it that if Mr. Carrim could do what is stated in those paragraphs, why is it that he cannot likewise do what he has been required to do, which is to furnish the information that has been requested repeatedly?
Paginated page 45, paragraph 53.1. I can't read it for obvious reasons, but I'll ask that.
Oh, sorry. For the record, let me just mention, because I did refer you to paragraphs by paragraph number.
Yes.
This time around, for the question I've just asked, the relevant paragraphs are paragraph 25 and 66.
Chair, I think it was 69 on page 25, and then, is it not?
Page 49, paragraph 66,
Yes.
and page 25, paragraph 69.
Yes, I did it, yes.
Yeah. Thank you.
Paragraph 25.
Thank you. Okay.
So that's the first answer, is the one that I gave, is paginated page 45, paragraph 53.1, which adds some color perhaps as to why something that is described as a simple issue or decision or divulgence is not as simple as it is. I would particularly ask the commissioners to look at the sentence beginning second comma on line 3 of that paragraph. That's the first part of the answer. The second part of the answer is paginated page 48.
Sorry, but what do you make of the word interactions there? Would that be the sort of interaction that the doctor is talking about here?
Yes, that's my submission.
Okay. All right. Please continue.
And on that page, if you look at the sentence beginning third, which is 4 lines from the bottom, that adds further color and context. The second answer I will give is paginated page 48, paragraph 65. It's a long paragraph, but the part of it I would want to emphasize is the last sentence starting at the top of page 49, which is just above the paragraph the chair referred me to, which is 66 on page 49. Starting rather. And it's 3 lines. So why I point your attention to those paragraphs is for 2 reasons. The first one is you've heard me already. I'm not going to repeat myself, but Chair views those 2 other individuals who I'm not going to name as having a greater role perhaps in the running of the businesses. I pointed out the fact that according to what the affidavits say, that is perhaps not correct, but obviously Chair will make his own assessment. And then the second reason I'm pointing you to these particular paragraphs is to say that even if it's as simple, in inverted commas, for an instruction to be given by Mr. Carrim to those individuals, those 2 paragraphs need to be borne in mind in respect of the instruction and the ability to give that instruction.
How I read this is this. What comes before 66, which is the paragraph I referred you to, what comes before 66 deals with why Mr. Carrim would ordinarily not be in a position to be of assistance. But what is in 66 qualifies all of that. It even uses by contrast. So it's contrasting what's stated in 66. So you can't read what comes before the contrast in isolation, as it were.
Yes, but with all due respect, I think if you look at 67, for example, the next paragraph down from 66, and if you look from the 4th last line from the bottom, regarding what the doctor says is his clinical opinion, then what Chair says to me is the qualification in 66 in respect of what comes above in respect of 65, which is the paragraph I relied on, is itself further qualified regarding Mr. Carrim and his ability, and what the inherent risk is throughout the proceedings. May I
ask this, and I hope this will be the last question I'm going to ask. Why is it that Mr. Carrim's founding affidavit, which is followed by a supplementary affidavit, does not deal with No, I will drop that.
Because it deals with that has to go to who the deponent is.
Yeah,
That's my answer.
I will drop that question.
But can I just say that my third answer to you, Chair, and this speaks to the context of the instructions that I said I would undertake to give. I'm reading from my phone and I'm paraphrasing, so this can be dealt with formally after the fact if needs to be, but I am told as follows. Contact was made by my attorney with the deponent of the founding affidavit, who contacted the treating doctor whilst he was consulting with Mr. Carrim. The purpose of that was to take an instruction on the issue that Chair and I were debating earlier. And we are advised that Mr. Carrim has suffered another medical incident and that no instructions can be obtained by him in respect of what Chair has put to me. and this is in the context of this facilitative process that we've been talking about. I'm also told that the clinician has expressed his frustration to Mr. Carrim's attorneys because, in his view, his client's position is deteriorating as a result of the pressure being put on him by his attorneys in respect of commission and commission business. And so what that relates to is exactly what I pointed out to you in those paragraphs I flagged. And that's the situation we find ourselves in.
I've remembered the question I wanted to ask. The mistake I made was to want to relate it to Mr. Carrim's wife, the deponent, to the affidavit. What I meant to do was to say, why is it that Mr. Carrim's doctor does not deal specifically with this issue? You will have noticed that...
About the, sorry, Chair, specifically the issue, the accountant auditor issue.
Yes, why I raise it is because that's quite pertinent, and the doctor has dealt quite extensively with some matters of detail, even dealing with issues relating to his whereabouts. And if I read his reports correctly, I do not recall that he deals with this aspect at all. And to explain why Mr. Carrim cannot furnish the required information. I might be wrong. Maybe it's somewhere there. That is somewhere in the reports.
Well, and I think this is the best answer I can give you. If you look at paragraph 53 on paginated page 44, that will tell you about the doctor's intervention, so to speak, in Mr. Carrim's business affairs, or what he did in respect of Mr. Carrim's business affairs. A similar point is made.
But that's about him not running his businesses, which explains why someone else has been appointed.
Correct.
It doesn't answer the one issue. Such and such information is required by the commission. So 53 does not answer that.
No, correct.
Yes.
But I was...
That's not running his business.
No, correct. The point that I was going to make is 53 and 55 on page 45 give you the context of how the doctor enters the equation, for lack of a better phrase, which is to give the family certain advice regarding what happens to the business. The doctor himself never says that he gets involved in the business per se. He has a facilitative role where it's appropriate to play a facilitative role. And there are instances where sometimes that facilitative role is more restrictive, not less restrictive. And the answer for that is that paragraph I gave you on that same page, paragraph 53.1, page 45. So the reason it's the best answer I can give you is because the doctor himself says that whatever matter has to go to Mr. Carrim through the doctor is not just simply relaying a telephone message or relaying a question, but that the doctor himself has to make a clinical assessment at that moment in time, for example, about whether the question, if put, would cause a deterioration or not, or whether, even if the question is put, the answer given is a good answer or a bad answer for whatever clinical views the doctor themselves may have. So I can't speak to why he did not deal with that specific issue isolated as a line item. But you've also heard me that when instructions, as a real-life example of what has happened when instructions were sought, but that adds context as to why he might not have dealt with it. That's as far as I can take it.
Thank you. That's my last question. Thank you, Mr. Premhid. Yes, Ms.
Thank you, Chair. Is it my turn now?
Apologies to Ms. Hassan.
It was
No,
1 hour and 51 minutes.
No. It was what, a couple of minutes only. So it was it was by 15 minutes. Ms. Hassan?
Chair, I will be extremely reasonable, and I won't ask for an equivalent amount of time as Mr.
Which will
Premhid.
end at what, 9 minutes to...
It's 9 minutes to 4 now.
Yeah, so 9 minutes to 5. Please, yes.
So, Chair, can I do this? Can I just address the last topic you were debating with my learned friend and just close that off? Because I was going to deal with it in any event in the course of my address. But since you are on it.
The way the issues, or we'll deal with that at the end, maybe do that at the end. The issues about possible rulings. The two issues Mr. Premhid raised right at the beginning.
No, I'm talking about what you were just debating now.
No, I said I would raise those issues with you when you begin your argument.
Yes.
Should I perhaps address those right at the end?
Those were the issue of the footage.
Yes.
And the redaction of the record.
And the redaction of the record.
Yes. Oh.
Can I just deal with this topic that you were debating, and then I'll begin with those.
All right.
Turn to those rather. So just on this, because it's fresh in your mind, because you've just been having the debate with my learned friend. The few points I wish to make about it, because I must admit that I find it quite an extraordinary claim that has been continually held since the time the Commission first asked for those documents. Well, first of all, one is not even a document, it's just the name of the auditor. That's all. It's a very simple request. Why I say that I find it extraordinary is because that request was made as far back as when Mr. Carrim appeared in this commission. That was on 9 and 10 March. On 10 March, it was itemized. What the specific, it would form part of a list of requests that we had. We itemized the requests. In fact, I'm sure if we go back to the transcript of the 10th of March, somewhere towards the end of the transcript, it will be there. So this request is months old. That's the first thing I'd like to say. The second thing is that if we look at paragraph 66 on page 23, the paragraph reads the first sentence. In fact, let me just read the paragraph. Before 13 April 2026, before 13 April 2026, my husband was fully involved in his businesses. And then she explains now what that involvement entailed. But there's no explanation to us as the evidence leaders or to the questions that have been posed by the commissioners why these documents and this information could not have been provided between 10 March and 13 April. There's just no answer to that. Instead, what my learned friend does is he goes to the various paragraphs that have been debated just now. For example, on page 74 of the paginated bundle, where the chair, I think it was the chair who directed my learned friend to paragraph 40.1 and the person and the PA and the issue of the FNB accounts. And my learned friend tries to say, well, actually it was just a rubber stamping exercise because all she did was place an electronic signature. That's not borne out by the text in that paragraph. That paragraph doesn't say that's all she did. It says that's one of the things she did, is that she appended an electronic signature. But that's not all she did. That's not what that paragraph says. What my learned friend is doing is with respect, taking liberties with the construction of these various paragraphs, and he's straining to defend an indefensible proposition that there is nobody in the company or in any of these companies which do business in the amount of hundreds of millions of rand who can say who the auditor is or where to find the financial statements. And I'll just make one last point, because I mustn't, for the sake of completeness, on page 25 on the debate in paragraph 71, that his son has stood in for him. What that paragraph says is that he assumed overall responsibility for overseeing the businesses and ensuring that the operations continue in his absence. He is a central point of contact, attends to matters requiring attention, oversees the payment of expenses and the continued performance of existing obligations. And then read that with 67.3, which my learned friend went to explain, well, that the role of the son is that he doesn't make strategic decisions. Well, yes, that's true. 67.3 says he does not make strategic decisions or decisions concerning new business. So we're not making any queries in relation to new business. We're making a query that falls smack bang in the middle of what Mr. Carrim's son is responsible for, as articulated in paragraph 71. So those are our submissions on that particular topic. Now, I don't need to go there later on in my address. So, Chair, on the question of the redactions, we have no objection to that. On the question of the CCTV footage, what I'd like to say is that, and what I would like to make clear at the outset, is that the point of the evidence on Mr. Carrim's movements is not put up to try to disprove a psychiatric diagnosis. It's not put up to...
Chair, I must just interject.
I apologize. It slipped out.
This is now the second incident where slippage is occurring. It happened the last time as well. And I would ask through you, Chair, that the evidence leaders please pay extra special, careful attention to the choice of words, because of the exact reason we asked for an in-camera hearing. This is now the second occasion it's happened.
Chair, may I apologize? It's in the course of speaking off the cuff.
It should not happen. It simply should not. And as Mr. Premier says, this happened at the last hearing. Mr. Shaskalson did exactly the same thing.
I'm aware.
It should not happen.
My profound apologies. It was entirely unintentional.
Chair, may I just say, and I'm sorry to do this whilst my learned friend is now on her feet, but the fact that I've had to object has itself now drawn attention to something potentially. And so my client's rights are now really being prejudiced because, and I make no statement about Ms. Hassan, who is a consummate professional, and I fully accept it might have been an accidental slip. But even the fact that I've had to record the objection now elevates the issue and creates the very damage that we've tried to protect my client from. And I'm in an invidious position where I am where I am. And so I would ask, Chair, not that you can control the media or anybody else, but just to remind people about their responsibilities in what they say publicly regarding the impact that can have on the dignity and privacy rights of someone who's made an express claim for confidentiality to avoid this exact situation. And I'm sorry to interject my learned friend while she's on her feet, but I have to now place this on record as a matter of principle that we're heading into dangerous territory.
Thank you, Mr. Prem, for now, let's leave it at the point that I have made, the admonition that I have made, and let Ms. Hassim continue.
Thank you, Chair, and I do reiterate my apologies. It was entirely unintentional. It's difficult to take out from one's head all of the information we've been looking at and reading and dealing with over the last few days. What I wanted to say was that the point of putting up the evidence on the movements is not to disprove any diagnosis, not to use it to challenge the clinical findings of a treating doctor. But it is important because what it does is it bears directly on Mr. Carrim's demonstrated ability, his day-to-day functioning capacity.
To start flighting or not flighting?
That's right. So,
are you saying you require flighting for purposes of what you've just explained?
No, Chair, it was just a preliminary point to explain why we go here at all, that it's not simply for the purpose of showing that Mr. Carrim was in fact in Durbanville on the 14th of July. It's not merely for that fact. It's more than that. But I can continue to make my submissions to the second point that I'm raising about day-to-day functioning without flighting the footage. And I will make that.
Yes, that's exactly how I understand it. I do not see what stands in your way to make those submissions without flighting. I simply do not understand. But as you say, you've just said now, you are able to make those submissions. So
I'm perfectly, I don't need to rely on the footage in order to make those submissions. And
because there's the admission by Mr. Carrim through the deponent, his wife, that he was indeed in Durbanville and at this particular shopping center, that he went to Woolworths and this other place. I can't pronounce that name starting with a K, with many vowels in it.
Kauai. So I'm going to talk about that evidence, but I don't need to flight the actual CCTV.
Thank you. So that takes care of Mr. Premi's, one of Mr. Premi's 2 points.
I think both, because we also have no objection to the redactions.
All right, thank you. There was, what was the third thing? Oh yeah, there was the issue about the geolocations.
Oh yes. I think in the context of the sensitivity of what we're dealing with, and perhaps, Chair, I should just refer to the ruling that you made yesterday, because that's the constraints that are governing my ability to make submissions to you candidly. So the ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand why we're talking in this coded way. So paragraph 2.1 says the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Carrim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Carrim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Carrim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Carrim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Carrim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the chair?
Why not use first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right, so I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Carrim will be incapacitated has varied and grown each time. So in the beginning it was a few weeks, then it was 8 to 12 weeks, then it was 6 months in the latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the 5th postponement that Mr. Carrim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Carrim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle. And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Carrim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that that we have now received the further medical report. This report is highly personal. Suffice to state that our client has been laid off for at least 8 to 12 weeks, and that was all. No medical certificate or report or note or anything accompanied this. It required requests from the attorneys for the Commission to obtain the necessary medical report to underpin the postponement request that was made. So that's the history that we're dealing with here, which is why the evidence leaders feel so strongly that getting finality and a specific date is so critical. We then come to the latest, I'd rather go to the most recent history on the postponements. The last postponement was to 15 July. Up until that point, all of the postponements were granted, were permitted on the understanding by the Commission and the evidence leaders that Mr. Carrim was hospitalized and that his movement was restricted. That's what we were led to believe. It was only when there were the two whistleblower reports on the 14th of July that the issue of Mr. Carrim's movements were put into question. The evidence leaders then obtained the CCTV footage to corroborate what we'd been told by the evidence, by the whistleblowers. Mr. Carrim was then afforded the opportunity to bring a substantive application for the postponement. And in that application, an opportunity was provided to address the latest information regarding Mr. Carrim's movements around the Cape. And this is addressed in two affidavits. The one, as we've already been talking about, is by his second wife, and the second affidavit is by his doctor. What we were told in those affidavits is important. Their accounts, and I'm not going to go into the detail, it's summarized at paragraphs 39 to 44 of Ms. Berger's answering affidavit. What we saw there was a particular picture that was painted by the two deponents, and particularly by Mr. Carrim's doctor. That picture was one of restrictions on Mr. Carrim's movements and interactions. We were informed that any leave from the hospital would be authorized for specific purposes, that there were passes that were subject to strict conditions, including searches, etc., including on the return of the 14 July excursion, which was said to have been a 4-hour chaperoned excursion that took place between 1:30 in the afternoon and 5 p.m. in the afternoon. That was the account that was provided by their doctor. It was supported by Mr. Carrim's wife. Now, it's important, commissioners, to go to those affidavits. So let's look first at what Mr. Carrim's wife says, and that's at paragraph 60 of the founding affidavit. if I could ask the commissioners to read paragraph 60 and its subparagraphs, where the 14 July incident is explained. I'd like to place emphasis on 60.2, where it says we departed the facility at 1:30. Then 60.3 and the description of the Kauai engagement. 60.4 and 60.6. Specifically where it says we returned to the facility by approximately 5. And then there was a consultation that they both, I've emphasized the word we in 60.6, attended. In paragraph 73 of the same affidavit, the deponent summarizes all travel since 13 April 2026. And I draw your attention to paragraph 74, where the deponent says, my husband undertook no other travel during this period and did not travel to Mahikeng or any other location in the Northwest. There's a second affidavit which I'm going to come to, in which this is a different picture is painted. And what the deponent says later is that that trip to the Northwest took place during the week when Mr. Carrim is with his first wife. And so, says the deponent, she did not know about the trip, and that's why she didn't say anything about it. What my submission on that is that that's implausible when we have regard to her own evidence that she communicates regularly with the first wife, and we'll see that at paragraph 15 of this affidavit, of the founding affidavit.
But what about the fact that she says this was the first wife's week, and that she might have missed this visit to Mafikeng or Mahikeng because of that fact?
Yes. I'm saying it's not plausible because they communicate regularly. She explains in paragraph 15 that they communicate, she and the first wife, including about...
Does that mean every and anything of necessity?
No, Chair. So let me then go to paragraph 15. It's because what they communicate about is Mr. Carrim's well-being.
Yes.
And his health.
Yes.
And updates on.
But as I understand it, it was Mr. Carrim who wanted to go there to see. Yes. Was it his daughter? I think to see.
Yes. I have no objection.
His daughter.
Yes.
Now, so it wasn't as if I'll be with our husband in Mahikeng, but I'm concerned about his health, because the travel might do this and that to him, in which event the first wife might have had to tell the second wife. Now, this is just a visit to the daughter, which was quite important to Mr. Carrim, because as I understood it, he had not seen her for...
Chair, we don't even need to get into that. We don't take issue with his wanting to visit.
But my point is, with nothing that has been suggested about his health and him going there, I do not see why it would have been necessary for the first wife to tell the second wife about the Mahikeng
for this
visit.
reason. for this reason, Chair, because there was a medical incident.
Sorry?
There was a medical incident.
By the way, which resulted in his...
In the second wife, accompanying
in his
Mr. Carrim.
return. In his
Correct.
return. Okay.
Correct.
No, I get it. I'd forgotten about the sudden need for him to return. Yeah.
That's right. And it was the deponent who took Mr. Carrim to the doctor and accompanied him and was with him during the consultation. And so that's why I say...
So your point is it's unlikely that the second wife would have forgotten about this incident.
It was specific.
Yes.
I'll tell you why.
Yes.
Because it wasn't a broad question, tell us about the movements. It was, a specific question was asked about movements to the northwest, because that was something that became contentious.
No, I get the point.
Then we have the doctor's version on the 14th July in his first affidavit. And we'll find that at paragraph 45, and I think it's page 43. 43, thank you. So in paragraph 45 is where the description of the 14th July incident is. And what's important here is the confirmation that it was 4 hours, that it was for the purpose of purchasing toiletries, over-the-counter flu medication. In 46, the doctor says, in terms, the facility's records reflect that he departed at approximately 1:30 and returned at approximately 5. He goes on to say he doesn't know anything further about the precise movements during the 4-hour period for which it was authorized. And then says, but in any event, these kind of excursions are not unusual. I'd also like to take the Commission to paragraph 39 of the affidavit of the doctor, because, and that's at page 41. Here too, the doctor says, in terms, I deal next with the facility's leave regime, because I understand that an impression may exist that the facility is a place a patient may enter and leave at will. That impression would be false. And then he explains there's only 1 or 2 ways that a person could leave on the pass of the treating doctor. Or the only other way is if the person discharges himself. What happened next was that the evidence leaders obtained geolocation data. That's the data of Mr. Carrim's cell phone that tracks the movements of the phone. We know from the first deponent that Mr. Carrim keeps his phone with him. We presented that information to Mr. Carrim's legal representatives on the 17th of July. That then prompted 2 further affidavits. So, if I can just go to the first, it's the supporting founding affidavit. Sorry, it's not supporting, it's the supplementary founding. What we see now, what page is it on? It's page 58.
That's where it starts. You want to take us to which?
To the paragraph. I'll do that, Chair.
Oh, all right.
Just trying to find my own reference. Right, I've got it. It starts at paragraph 27. Page 67. And that's where the account is amended. It's confirmed in paragraph 27 that Mr. Carrim was at a shopping centre, that he was at Woolworths, that he was at, she says he then purchased a meal from Kwai, finished his meal at Kwai, and thereafter obtained flu medication. He was supervised throughout by his security detail.
And an important contrast here is that he did not buy a takeaway and go and eat in his car. He actually sat down, had a meal in Kwai, or whatever it's called.
Yes. Yes, at Kwai,
The owners will not be happy with me.
I think they'll be very happy with the free advertisement that they're getting. But so, Chair, the discrepancies are, that's the one. The second is that if you look at page 68, paragraph 28.3, I'm not going to, I can't read it out.
But is the second point you want to make the fact that this pass was not was it 4 hours, the shorter period mentioned? It was not for that, but
Much longer period of time.
Basically, I may be exaggerating if I say close to the entire day.
It was
8 hours or upwards?
It was almost 12 hours.
12. Yeah.
So, as confirmed by this deponent, who says when he arrived at where she was in the morning.
I'm doing that. That is going straight to the number of hours to avoid reading. But
Okay.
I'm not even sure that that's what you wanted to read.
No, that's the second point, which is that the discrepancy in the time.
The hours were much longer.
Yes, so it's two. It's the time of departure and then the time of return, which was about...
And the fact that they did not depart together, which is what was in the first affidavit.
The first one was the we that I'd emphasized. They did not depart together. And the second thing is that they did not consult together either with the doctor upon return. And then the final thing is that consultation took place much later at night than just after 5 o'clock. The deponent also corrects the facts on the travel on the 9th and 10th June to the northwest. And what, yes, those really are the main things that I wanted to make clear from the first deponent's affidavit. The final thing I'll say is that she does also confirm, and that's at paragraph 20 of her affidavit, and this is important given the replying affidavit that came later last night. Paragraph 20, yes, page 65, where the deponent confirms in the middle of the paragraph, I am unable to identify every such occasion, and that is travel and leave excursions from the facility. Subject to that qualification, she says, I accept that the geolocation data generally reflects my husband's movements. I do not dispute the accuracy of the data or seek to explain it away. We've explained in the answering affidavit the analysis of the maps and the geolocation data and what they show. And what they show is that almost every single day, Mr. Carrim leaves the facility. And that on most days, he's out of the facility for at least 8 hours, sometimes longer. So which is what my learned friend was objecting to, the inverse inpatient reference that was made in the answering affidavit, was that he spends more time outside of the facility than he does inside the facility, is really the point of that. So what we get now is a materially different picture from what we first had. And when I say what we first had, I'm saying let's go back. I'm not going to do it now, but if you go way back into history from April, the picture keeps fluctuating. And it fluctuates recently when Mr. Carrim's, when the deponents are provided with objective information from the Commission that changes the version that they initially gave. So that information is not information that is in our knowledge. That's within their knowledge.
Please continue.
So what the crux of the point here is, Chair, is that these shifting accounts in the affidavit are important because they show that each time that the deponents are presented with, confronted with objective evidence concerning Mr. Carrim's movements, the explanation changes. Second, and this is important because of the ruling that we seek from the Commission, it underscores why an independent medical opinion is now imperative. And without impugning their doctor's integrity or professionalism, it's apparent that he has not been placed in full possession of the facts concerning Mr. Carrim's comings and goings from the facility. So his own medical assessment and the report that was furnished to the Commission appears to have been based on a flawed factual foundation. So that's another reason we say that the independent medical opinion is required.
The doctor, you've referred us to 4841, where the doctor states that a patient may only leave the first, and underline only in one of two ways, which is a pass by the doctor. And also if a patient wants to discharge themselves. But in the later, should I call it what, a supplementary affidavit? Yes. In that one, the doctor now makes a suggestion that other people may, I hope I understood it correctly, other people may, I don't know whether actually issue passes or allow a patient to go out. But other people now are involved. Whereas in 40, he said only only one of two ways, a pass by the doctor or.
So now what the doctor says, and it's at paragraph 16 specifically, is that if he's not available, then the nurses will authorize.
That's the point I'm making. Thank you. Yes.
So which is a very fundamental change from the first affidavit. You don't need to have been presented with this data that we provided him with, of the geolocation of the phone and the movements that we obtained independently, in order to make an accurate statement from the get-go about how movements take place in the facility.
And it is quite telling that you have these movements in the allegations on Mr. Carrim's side, not by one person only. The second wife also moves or changes her allegations once confronted by facts that contradict what she says. And unfortunately, this is happening with a doctor as well. A patient may lawfully leave the facility in only one of two ways. But later, once we have the geolocation and the times when Mr. Carrim would be out of the facility, and suggestions of much, much longer times than what we were made to, or given to understand, the doctor as well, just like the first wife, moves and changes, and now tells us about the possibility of nurses also issuing passes.
So we didn't ask for this specific question of passes to be addressed in the founding affidavit. That was done of the doctor's own volition. So if the doctor is providing an account of how the system works, why was that not part of the account in the first place? Why did it come up only when presented with different evidence? The second thing is that, that's why I read it out earlier and said, he said so in terms that the facility records will show entry and exit. That changes in the second affidavit. And you'll find that at paragraph 18 of the supplementary affidavit.
That's at page?
What? Page 84, I'm told. So just paragraph 16 on that page is the nurses. And then paragraph 18 is where the doctor explains that in fact what he said wasn't correct because the facility protocol is not followed, that in fact the practice of keeping records is that it's just not honored. There aren't any records. The doctor also tells us that he himself doesn't keep records. He doesn't keep his own notes of when he issues or authorizes pass-outs. But he only tells us that in the second affidavit. Sorry, bear with me, Chair, please. I'm trying not to make a mistake again, so I'm going a little more slowly. The most charitable interpretation of the doctor, he is relying on what Mr. Carrim tells him about his movements. He now knows that he's not being told the truth about the movements. But all those facts were the facts that he based his information on when he gave us these reports. Those reports do not hold true anymore. So my learned friends...
Although that charitable interpretation would not apply to the categorical statement that doctor makes, which is people go out only, and he specifies the circumstances. Yes. So your charitable interpretation cannot apply.
Maybe I'm being too charitable. But the point...
I'm not suggesting you should not be, but I'm just saying it cannot apply to that categorical statement.
No, it can't. Nor to the... I'll leave it there. I agree with the chair on that. My submissions are more to what it means then for the opinion that he expresses, in which he says to the Commission, this is the difficulty with, and again, what I wished to say at the outset was that the point of it is not to challenge the diagnosis. It's to say, what we're concerned about is functionality. What is Mr. Carrim's ability to engage with questions and information and evidence that may need to be provided to the Commission. That's what we're concerned about. We're not concerned with dislodging anything else, although it may become necessary, and I'm not going to preempt the independent medical assessment that will come. That will give us a better picture, of course. So we can't rely on that. So to say that this report by the doctor is definitive falls on that basis. But the argument that the doctor's report is definitive is also extraordinary for another reason, because it itself is a breach of the professional guidelines that are referred to by our doctor in his affidavit.
I assume you will obviously address the issue raised by Mr. Premhid, that applies in the context of forensic what? Yeah, which Mr. Premhid submits. That's not the instance here.
In fact, it's exact opposite. It is exactly the circumstance here. I'm coming to that doctor's report, but it's precisely, those guidelines were prepared for precisely the scenario that we're facing today. So I'll come to that. For now, what I wish to say...
I must say, I didn't quite understand why this is not forensic, and which is why I put the question to Mr. Premhid, but we'll hear you when you get there.
Thanks, Chair. What my learned friend argues is we must accept the opinion of their doctor. That opinion, as we will see when we get to our experts' report, is provided in breach of those guidelines, those professional guidelines, which say that a treating doctor should not be the person to provide an independent assessment, and of this is the critical thing, of the individual's, the patient's capacity, which the commission is expected to consider, right? The objective determination of the capacity. So not talking about diagnosis, but it's about objective assessment of that person's capacity to participate in these proceedings. The guidelines say that it should not be provided by the treating doctor because the treating doctor is inherently subjective and an advocate for the patient, and I'll come to it because he says more things, and I'd rather refer directly to what our expert says. But so that's the thing. This is the first thing, right? But we must accept it, says my learned friend. And then what they say is, and with the support of their doctor, they say that then the witness must be insulated from any examination by an independent specialist. And no one is able to then assess whether that conflicted, what we say is a conflicted determination of capacity by the treating doctor is in fact reliable. Because we've gone through the passages, I'm not going to go back there, the paragraph 73 and 73 of their doctor's affidavit, saying that there should not be an independent examination. I don't know yet where we stand on. I know there was a discussion about interposition of another physician, etc. That's not what we are proposing in any event. We're proposing something that is entirely squarely within the professional guidelines. So they say, and they've been saying to us, and Chair, let me just say in response to the question you posed to my learned friend about, sorry,
I wanted to, don't forget the point you wanted to address now, but I wanted to say, is it not semantics to say the IM, is it E?
Yes.
That the IME issue differs from interposing a different doctor. I don't quite see the difference you appear to be seeking to draw, because you would still be bringing in a doctor that's not the treating doctor.
That's
so,
right.
So why you would say that's not interposing another doctor? I don't quite, yeah, it's not a serious issue really. It's
maybe not, but it's important because we want to address the concerns that have been raised.
Okay, all right.
And it has been addressed by our expert, who explains that doctor doesn't take over the treatment of the individual.
The suggestion about interposing is not about this doctor that's being interposed, taking over. It's not about that. It's just for purposes of also doing an assessment.
Yes.
with a view to either confirming or not confirming what the treating doctor has said. So I'm not quite sure that I still do not get the difference you're saying.
Okay, that was my understanding of the difference. But if the interposition goes to what the chair is now saying to me, which would include that, well, then
that's all I meant when I used the word interpose. That's all I meant.
Well, what the guidelines say is that it's not only permissible, it is required that there is an interposition then, in the sense that there's an independent assessment that's testing for a particular outcome, and that's why it's forensic.
Back to your point then, the point you wanted to make. I hope you have not forgotten it.
Well, Chair, yes. Chair, you posed a question to my learned friend about the lack of a response to the evidence leader's request for an independent examination, and we've set it out in the answering affidavit. There was a correspondence from I think May, if not earlier, in which that was requested.
And don't forget that correspondence was preceded by an undertaking by Mr. Carrim sitting in that witness box. So there's that, and then the correspondence.
And then the correspondence, which went unanswered on that point. We did get answers to other parts of our correspondence, but not to this. It's in our answering affidavit. This history is set out. Until we pressed for an answer on whether they would agree to an independent medical examination. It culminated in the hearing that took place, I think, on the 25th of June, which was the debate that you were having with Mr. Premid about what exactly was said in that hearing. And I think on that score, I'd rather just go back to the transcript and have a look at it. Our understanding was that there was an objection to an independent medical assessment, and it was quite plain in our understanding. But we can go back to the transcript and have a look at that.
May I request both counsel to furnish us, say, not later than the end of day tomorrow with the relevant part of the transcript?
Certainly, Chair.
Thank you.
So what we're told is, accept our guy, accept what his say so. No, you can't have an independent assessment. And then it gets even more absurd, because the next claim is that because no one is able to assess, the treating doctor's determination is unanswered. As we heard, well, it's unanswered, it's unchallenged, and so it must be accepted. So it's a circular reasoning in which...
It's exactly for that reason that I said it cannot lie in Mr. Carrim's mouth to say this is unanswered.
Yes.
Not in the face of what I understand to have gone on, but as I said, I accept that my recollection may be inaccurate.
Well, let me say this. I've not heard, and we know because apparently there was a need for an instruction, so there was never a response to that. At least from my learned friend's perspective, there was never a positive response to this, which is yes or no. So why not? That's the question. After so many requests, the stonewalling is no independent medical assessment, and then it's triumphantly, but you see, our doctor's unchallenged, and therefore you have to, and you, the commission, must be now bound by that doctor's assessment. So I think what I should now do, and I would say this, that if their doctor had given a response to our doctor's affidavit, we might have also, perhaps this would have been there would have been a shortcut through this. But there is no response. Our expert is unchallenged, in fact. And I'd like to go to our expert's report. What page is it on? page 125 is where the report
Please be
itself.
careful what you read.
So I'm going to go very slowly. And I think what I will do is just refer the commissioners and my learned friend to paragraphs of the report and try to deal with it in that way. But what I want to begin with saying is that this expert has attached his CV. He is the former chair of the professional association that regulates the very field in which their doctor practices. He's extremely experienced, and he is the co-author of the guidelines that he refers to in this report. I'd like to go to page 126, paragraph 5.
Maybe before you do that, if you could just refer to, without necessarily reading it, paragraph 3, because it sets out the purpose of this report. And I think it's important on the back of Mr. Premet saying that this expert has not countered.
Well, yes, no. So this expert was not asked to do an assessment on paper of Mr. Carrim, nor could he have been able to do so because all that he was provided with was their doctor's affidavit. And their doctor, which is something that I should actually point out because it does go to the reliability of that report, doesn't set out the details of things like the treatment protocol, etc. And I don't want to say too much more about that, but there isn't that kind of detail in any event. So it wouldn't have even been possible for our expert to give a meaningful opinion based on that affidavit, which wasn't setting out the full details of the condition. So what he was asked to do instead was to comment on whether the objection, on whether it is clinically appropriate not to have an independent medical examination. That's what he was asked to comment on, and specifically to comment on the objections that were made by their doctor about the interposition or whatever the interposition is defined as. So there was no request for it, Commissioner Baloyi. And he would not have been able to do it even if he was requested because of the lack of information. And so what he does at paragraph 5 is consider the affidavit and the objections. And in paragraph 7, you'll see that he respectfully disagrees.
I noticed that your time is up.
My goodness. Chair, I now have to claim equality of arms.
Sorry, by how much did you overrun, Mr. Premier?
51 minutes.
No. I'm not talking. I'm not talking. Remember, right at the end, after Mr. Premier had said he was done. I'm referring to that stage, not when we then engaged him after he had said he was done. So the overrun released to before that lengthy.
It was 3 minutes or something like that. The additional 15 minutes comes from the panel engagement with me.
I'm not even counting.
Agreed. So equality of arms is 3 minutes, then not 51.
Ms. How much longer do you want to be? Considering fairness to Mr. Premier, I may have to increase the 15-minute reply time for reply.
A very charitable approach, Chair.
But how much do you? How much do you?
What I'll try to do is spend less time on the legal principles. They're set out very clearly, I think.
Take that as read. Take those as read.
So may I have 10 minutes, Chair?
All All right, 10 minutes then.
And if I can do it in less time, I will. And one way to do it is to refer the commissioners to the paragraphs, the relevant paragraphs of our experts' affidavit. The statement, it speaks for itself.
Yeah.
The disagreement is in two respects. One is that it disagrees that an independent opinion should not be obtained, and second, he disagrees that if there were to be an interposition, that there would be therapeutic harm. In fact, he says not to do so, to require the treating doctor to provide their opinion threatens that therapeutic relationship between the doctor and his patient. So I'm just going to say paragraph 10.
At page 127.
Page 127, if the commissioners could just read paragraph 10. I can't deal with it reliably, it would be too risky, but it explains why the independent medical examination has become necessary part of the guidelines, because you need an objective view in the context of.
Okay, you've made the point that it deals with why. We'll just focus our minds on that.
Yes.
You don't need to go through it.
And specifically, just one sentence, these challenges, I'm not going to say what the why are the challenges, but these challenges, if you read in the middle of the paragraph, may hamper the goal of insurers and the courts making sound decisions.
All right.
And then I recommend paragraph 11 at page 128.
Okay, we see that.
And paragraph 14. And then finally, paragraph 19, the conclusion.
Got that.
Then, Chair, what I would also commend to the Commission is the actual publication, which is attached to the report. I'm not going to go there. It's a minefield. There are just bombs all over it, and I don't want to make another mistake, but it's an important report. What I want to say about that report, it's published in a journal of the field, is that it's authored by several highly regarded experts in the field, and it's
I saw reference to it saying international, am I mistaken? Or am I thinking about anything? I did not see peer-reviewed.
I believe it is a peer-reviewed journal,
Okay.
but I could be, I'll stand to be corrected, and I can double-check whether it is in fact. It is the journal of the profession. It's accredited, I saw that. I can't remember if it said peer-reviewed.
In our field, in the legal field, it would never be accredited if it is not peer-reviewed.
Indeed, indeed so. So, and the one other thing you might have seen is the reference, because part of the literature, this is not a purely South African approach, these guidelines. So this report, these guidelines that are published in the journal also rely on medical literature from other parts of the world. And we referred to one, in fact, we pulled out an abstract of that article for the assistance of the Commission to show that this is not something that is unique to, it's not something that comes out of Mr. Expert's head. I'm stopping on that now. Yes. All that remains then for me, all that remains then, this is the most harrowing submissions I've ever had to make given the constraints of the ruling. And so I'm going to now draw to a close very quickly, because all that remains for me to say is that we've set out the authorities. The closest analog is the Kwelane judgment by the Constitutional Court. It's in our heads of argument. That judgment also cites very established principles on postponement, which requirements of postponement applications, which I've no doubt the commissioners can recite in their sleep. But importantly, what it says is that if there's a request for a second opinion and an independent medical opinion, that should be permitted. And the foreign authorities support the same, and then of course Michael versus Linksfield and so on, that a commission and a tribunal and a court are not bound by an expert opinion. The foreign authorities are useful because they are in a similar field as to the condition with which we are dealing with here, and it explains what the standard is for sufficiency of evidence, and importantly, independent expert evidence on the issue. And so I commend to the Commission those judgments. And
I wanted to clarify your expert's report, because you refer to it in the evidence leader's affidavit. You say there's no reply to what you refer to.
There's no reply to our expert.
Yes.
That's correct. I mean, other than what we've heard from Mr. Premid, I mean, their doctor, their expert, hasn't challenged the affidavit. So, Chair, we request that a postponement on the Never Never must be rejected. We request that the 14th of August be fixed as a date for Mr. Carrim to appear, and that in the intervening period, that there is an appointment of an independent medical examiner who will provide a report, and that might affect then the date of the 14th of August, but at least it will be on the basis of an independent expert. Thank you, Chair.
Thank you, Ms. Sim. Can we take a short adjournment? I won't indicate a time. We'll indicate when we are ready. Let's adjourn. Mr. Premier, 20 minutes?
Chair, very generous.
Thank you.
Chair, can I start where Ms. Hassam ended, that there's apparently been no reply to the Commission's experts' report? You'll find that reply at paragraph 16 of the replying affidavit at pages 334 to 335, which I'm not going to read for obvious reasons, except to please point your specific attention to what is said at paragraph 335, on page 335 at paragraph 17 and paragraph 18. Because with all due respect, several inaccuracies have been raised about the quality of the affidavits and the reports presented by the treating doctor. And even though my learned friend says that the Commission is not impugning the treating doctor, in effect, that's exactly what they're doing, both his bona fides and his clinical expertise. And in the affidavit that is filed in those paragraphs and pages I referred you to, and that it's confirmed by the doctor himself, that's the full answer. In fact, what our doctor says in response to their doctor, if I can use that phraseology, is that it actually confirms our doctor's position, which is if there's going to be any such interposition, that our doctor has to be involved in that process. And in fact, if we read their doctor's report, their doctor says exactly the same thing in terms. If I'm not mistaken, at paginated page 129 and paginated page 130, this is of their doctor's report, he actually says the following: the Commission should even advise the independent doctor that the treating doctor is the treating doctor, wishes to be engaged by the independent doctor, and he goes on to say, in my experience, I have done something similar. He goes on to say at page 130, it is my opinion that the engagement between the independent doctor and the treating doctor should occur before the interview by the treating doctor, the independent doctor, so that the independent doctor understands the treatment plan, etc. So the point is, and why, and this chair goes to that IME forensic distinction, is to say the kind of exercise that the Commission's doctor is speaking to is a different exercise to be performed by an independent clinician. Our doctor has never pretended once to be performing an independent medical assessment inquiry. He is the treating doctor, and he's giving his clinical opinions. And this report does not dislodge that. All it says is that if there's going to be the subsequent process, this is how it must occur. And whilst I'm there, in response to this question about the instructions and why was it never responded to voluntarily or not voluntarily, when Chair and the Commissioners read the correspondence bundle, you'll read the correspondence bundle at page 123, going on to page 124. And at page 123, all I'll emphasize is that paragraph 10.1, which says, before our client takes a final position on the Commission's request for independent examination, the evidence leaders are required to identify a series of things, and then over the page, it goes on to 10.2. I only highlight that because it's not as if it's accurate to say that there's been no response. Consistent, Chair, with the debate that we've had before, can it be voluntary? Can it be compulsory? Do you have a power to even order a voluntary one? Those are what those questions are directed to. And with all due respect to the Commission and the evidence leaders, there hasn't been a response to that. So never mind what I put on the record earlier regarding the medical incident of my client when an instruction instruction was to be taken. It's actually the evidence leaders who haven't responded materially to those questions, which my client expressly says through his attorneys will allow us to take a final position on this question of the medical examination. Because of course, Chair, if there are insufficient answers to those questions, particularly the question at 10.2 in bold, which is on page 124, statutory authority, it doesn't matter whether it's voluntary or compelled. If you don't have the power, you don't have the power. That's an ultra vires question, admin law 101. So on the question of whether there's this medical exam or not, that's the fullness of the answer.
That's exactly the level at which you and I engaged the virus question. Is there a power?
Correct.
And in a sense, once that issue is raised, you have no power. That would supersede or not the conditionalities at page 123.
Correct. It would. But the point that I would make in that regard is that if the Commission believes it has the power, then it must exercise its power and do so. But we can't be caught in an endless loop where the question is asked, where's your power? There's no direct answer, and then you get accused of not answering the question or giving a position where knowing the source of the power is a fundamental issue that requires clarification. And obviously, if the Commission decides it has the power and makes such a directive, and there's a challenge to be raised to that power and the exercise of the power, then the challenge will be raised. But it's all this indirect inferential reasoning rather than directly dealing with the issues that I'm raising here in the context of what I've just flagged with you, Chair. That takes care of a few of my submissions. Let me move on to the next few. What my learned friend said at the beginning of her address is that it's an extraordinary claim that we've made that our client is unable to give the information that was sought as far back as March. Now, I'm not going to argue the point. I'm just going to direct your attention to medical opinion, which has not been contradicted. The first of that medical opinion you'll find at page 37 of the record, paragraph 26. And I would emphasize that when you read, look at what it says as lines 2, 3, and 4, starting with it materially and ending with the words identified triggers. That's medical clinical opinion as to what or why the information can't be given.
Mr. Premier, this doctor only saw your client from when? Because the period from March until 13 April, he cannot express an opinion on that. He simply does not know what the position was. He was not there.
I'll respond to you in 1 second, Commissioner Khumalo, if I may. Commissioner Khumalo, I've asked Ms. Madlanga to find a particular reference for me that answers your question, because my understanding of the doctor's position is that the phenomenon the doctor observed, diagnosed, and treated after he came on board as the treating doctor suggests that actually the condition could have arisen and materially impacted Mr. Carrim even prior to when it was diagnosed and treated thereafter. So I accept your...
Yeah, but that's speculation.
Well, it's... And with all due respect, I'm not sure if you can say that having regard to what the doctor has himself said, but be that as it may, if it's speculation or if it's not speculation, that can be tested. And the point of the matter is the doctor's view is that what I've observed from the incident when I came on board onwards suggests to me a long-term medical issue which may have impacted things before. I can't take it further than that. So I gave you the first reference to page 37, paragraph 26. The other reference I'll give you is on page 96 at paragraph 51. And I would ask you to start reading from about midway in that paragraph. in the 8th line, when it starts with the word when. And I would ask you to read after that next sentence in the 9th line that starts in a state of blank, and then it goes on to speak what a consequence of his giving information in those situation might result insofar as accuracy, reliability, recall, or anything else is concerned.
At what line do you stop? Below when? Below the line starting when? At which line do
I'm
you
saying
stop?
the entire paragraph, but I was emphasizing those particular portions, the one starting when, the one starting in a state of blank.
Okay.
And then the next one that starts with any information. The last reference, or second last reference I'll give you, is at paginated pages 48 and 49. I think we've been here already, we've gone through these paragraphs. I'll just give you the places where I would like your attention, please. Just look at what is said in paragraph 65 at the end of paginated page 48 that starts with, I had raised this concern. And what he says at the end of that page, interaction, words, 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 until the full stop. And then I would say, when you're looking at page 49 at the top, still paragraph 65, look at what is in the third last line that starts with rather, and what the conclusion is regarding any information that may have been given or may have been procured. Whilst you're at page 48, 49, please also look at paragraph 63, and then what follows. Commissioner Khumalo, I say expressly, I don't think that answers the challenge in the way that you put it to me, but I've asked Ms. Madlanga to find that reference. The pressure is on her now.
From 4 May, I get it.
Yes.
But from March, April.
I know. But what he does not say, importantly, is that the phenomenon only started on 4 May onwards, because it's an ongoing phenomenon that he's treating. But I take the point, and that's the response to you. You've already heard me on, are we impugning the doctor or aren't we impugning the doctor? May I just say this? This doctor has made himself available to the Commission in numerous instances. And the peculiarity of what we're dealing with here is, if you took one step back from listening to my learned friend's submissions and my submissions about who's expert and whose expert is correct, or whose one's medical opinion is of greater validity, you would almost be in a situation where we were in a trial where you were cross-examining two experts and running two experts' evidence against each other. As in expert against expert, not even expert against expert in respect of Mr. Carrim himself. The only reason I point to that is that if that's the Commission's real concern, then the elephant in the room is they think that the doctor is a liar, and they have the weaponry available to them to test whether he's a liar. And all these inaccuracies, whether they're of a material kind or not a material kind, I see Chair is getting ready, maybe I should stop.
Please, you overdo this thing of reading what a person does. I mean, should I not lean over? Should I not place my hand on my file? Please, Mr. Premier.
Oh, sorry, Chair. I thought you were going to engage me on what I was saying. That's why I preemptively stopped. I also have the other problem when the judge is trying to intervene and I don't then yield.
I remember at the Constitutional Court you reacted to two of my facial expressions.
Yes, indeed. But I don't mind that because you found for me on that occasion, so that's fine, Chair. Unlike what happened in the interdict yesterday, but that's besides the point. Chair, what I'm saying is that if this doctor is so unreliable, or his evidence is so open to doubt and to question, Why on earth would this doctor under oath volunteer himself to come and give evidence and be cross-examined under oath? The approach of the Commission, with all due respect, has not been to take a benign or neutral position towards Mr. Carrim, the deponents of Mr. Carrim's affidavits, and even the treating doctor. It's been that, and I'm speaking in forceful language, but I preface what I'm about to say with the fact that my learned friend didn't put it in these terms, but this is the conclusion, and we must call it out for what it is. In their view, the evidence leader's view, Mr. Carrim is avoiding accountability at all costs. He's using the deponents of the affidavits and treating clinicians to aid him in order to do so. And that's why they want to unpick, with all due respect, the most direct medical evidence in front of the Commission in order to go after Mr. Carrim. But the one thing they haven't done is they haven't called the doctor to be cross-examined by them, and he's volunteered himself to do so. So that's why this weird world in which we exist, with all due respect, is a difficult one for Mr. Carrim's legal team to have to engage in, because even when the doctor volunteers himself, instead of bringing a rebuttal witness to directly deal with his clinical views, which is a possibility they could have done, or by calling him through a subpoena to come give evidence in camera and be cross-examined, they want to put up all kinds of geolocation data and CCTV footage to impugn the doctor's medical views through the back door where there's no clinical basis to do so.
No, Mr. Pramit, I think it's grossly unfair that you would formulate the position of the evidence leaders to impugn the medical opinion. They are lay people. They're lay people. They could never pretend to do that, and I've not understood them to be doing that. That is different to speaking to the facts alleged by the doctor. When the doctor says the hospital protocol is that you can only leave in 2 circumstances, that's not a medical view that he has expressed. He's alleging a fact, and it's relevant information to be brought to the attention of the commissioners through the evidence leaders, and the geolocation material. As Ms. Hassan says, what has always been the impression is that Mr. Carrim is in hospital. He's confined to a hospital, right? And once there was information that, in fact, he doesn't spend all his hours in a hospital, that's relevant information to be brought to the commission. So you have absolutely no basis to criticize the evidence leader's position as being to impugn the medical opinions of the medical conclusions and opinion of the doctor. I would be shocked if that's what they were doing.
Me too, with all due respect.
My first question would have, and that's not what is in the papers. My first question to Ms. Hassan would have been, on what basis? In the same way, in fact, that I would like to ask the question, the deponent to the replying affidavit is a lay person. On what basis could she pretend to answer the commission's expert views, as you have referred us to your paragraph, right? Is that an answer really in response to the concern raised by Ms. Hassan that there is no reply or answer to the commission's expert? So let's not fudge things for whatever purpose, we're seeking to achieve. As I see it, or as I understand it, the simple position is this. There are certain facts that have been relied upon by the deponent to the affidavits of Mr. Carrim, supported by the doctor's affidavit. All that has happened is to answer those factual or to raise issue with the facts as set out, and none of it speaks to the medical conclusions. I differ with you there. Maybe my co-commissioners agree with you, but I differ with you. I do not see that.
I actually agree with Commissioner Baloyi. What the evidence leaders have done is to say Mr. Carrim must be subjected to an assessment by an independent doctor. And that's exactly because they, as evidence leaders, cannot purport to contradict the Mr. Carrim's doctor's opinion. That is why there's this insistence on let Mr. Carrim be subjected to an assessment by, it would be that independent doctor that would counter all of the clinical conclusions reached by Mr. Carrim's doctor. So at this stage, the point you make has not been reached, at least not on my understanding.
Well, but
yes.
Sorry.
But of course, a point is made, but on what Commissioner Baloyi refers to as facts. A point has been made that with regard to those facts, even what Mr. Carrim's doctor says, there has been a shifting of the goalposts, even by the doctor himself. That's a factual issue, and the evidence leaders are perfectly entitled to challenge the doctor on that.
I accept that, but then I would ask, my next question would be to what end and to what purpose? Because on the question of factual discrepancies, both of the deponents to the affidavit full square deal with the circumstances under which they were expected to depose to affidavits and the pressurized circumstances that they had to deal with various issues. And that's explained at pages 75, 76 for the one deponent, and with the other deponent, specifically on the medical records issue, you'll find that at 84, 85, and 86. So if there's an issue about the facts, so to speak, and the conclusions or the inferences that the commissioners are being invited to make as a result of these so-called inaccuracies, there's actually an explanation.
They are not so-called. They are inaccuracies, and Mr. Carrim's case, as we sit here, actually accepts those, that they are in fact inaccuracies, hence the shifting of goalposts. So they are not so-called.
I withdraw the word so-called. To the extent that there are inaccuracies on the papers, they're dealt with fully, and the surrounding circumstances around how those inaccuracies arose are fully dealt with. It's not uncommon in urgent applications, for example, that sometimes the deponent doesn't fully remember what it is they otherwise ought to have remembered. And it's only when they are advised of something in an answering affidavit that then in the reply they give the fuller account and context because of the pressured circumstances in which they were deposing. So all I'm saying is that let's accept the inaccuracies are for what they are. It's maybe unfair is too strong a word, but it's unfortunate to draw any adverse inference by the mere fact of those inaccuracies in circumstances where there's also an attempt to explain how those inaccuracies arose. But to the extent then those inaccuracies relate to movement and what can be said about Mr. Carrim's medical condition as a consequence of the facts of that movement, it's not a purely factual inquiry, because what the doctor says in terms at paginated page 44 of the papers, at paragraphs 49 and 50, is he says that the danger in analyzing the facts of those movements would potentially lead you to draw an inaccurate clinical conclusion, because the fact of those movements is not necessarily antithetical to the treatment he's receiving. In fact, in another part of the affidavit, he actually says that it might form part of the therapy process. So I accept what Commissioner Baloyi puts to me. Commissioner Baloyi rightfully says that they're not impugning his clinical diagnosis, they're just relying on these factual issues to say there's a problem here, and I'm being loose in my language. And so let's accept that there's a problem here, and then say what's the clinical opinion in respect of that so-called problem that's on the papers in front of you and not challenged. And that's what the doctor warns the commissioners from drawing an inappropriate conclusion on that those mere facts are elevated to considerations that impugn, or not even impugn, that open to doubt the clinical diagnosis, even if that's not the direct intention of disputing those facts. And what the doctor's evidence is regarding those facts is that they are what they are, and they might be what they might be. But you can't draw in based purely on those facts. You must be very careful in what conclusion you draw, and I'll put it no higher than that. So I think that's where Commissioner Baloyi, I was dealing more with the conclusion and the conclusions to be drawn from those facts, whereas I think, Commissioner Baloyi, you were focusing on those facts themselves, and I hope I've attempted to answer you in both respects why there's a danger in the exercise that we were just going through. Yes. I thought Ms. Madlanga had something for me. She doesn't. So that's on the issue of are we impugning or are we not impugning, and to what extent are we impugning? Just, Commissioner Baloyi, one thing that you raised, which is correct, the deponent is a layperson. What business does she have engaging with the report? If I'm not mistaken, there has or should have been a signed confirmatory affidavit from the treating doctor in respect of the content of the replying affidavit. And even if it doesn't say it in terms, I consulted with the doctor on X, Y, and Z, and he tells me, here's the response. I would ask in a generous reading of that replying affidavit and the fact that it's confirmed by the doctor that the so-called medical responses are medical responses from a non-medical person, but confirmed by the medical person themselves. It's not just the deponent offering her own opinion or thoughts influenced by the legal team or anybody else. So that, Commissioner Baloyi, I hope is a satisfactory response on those particular issues. Chair, I think I've dealt with everything that I need to. Might I just take an instruction, please? Oh, yes. I'm indebted to Ms. Madlanga. Commissioner Khumalo, back to our debate about the timeline and the date and when it started and everything else. The reference I had in mind starts on paginated page 36. It's the heading you'll see there under paragraph 18. And then through you, Chair, Commissioner Khumalo, over the next page, well, it starts at the bottom at paragraph 22.
18 says exactly what I said.
Yes, agreed. And then I'm asking you to read 22 at the bottom of that same page. Particularly where it says health conditions appear to predate the commission. It then talks about his history. And over the page on page 37, I would say that I would draw your attention to the last line, starting 3 lines from the bottom on page 37, paragraph 22. It starts with, I emphasize this because the underlying blank, blank, blank. I know that might not be satisfactory to your question. I'm just giving you the reference that I had in mind when I answered your question.
It's also factually incorrect.
Thank you, Chair. I'm indebted.
Thank you, Mr. Remit.
Chair, may I ask a clarity, please, before we break up? In passing, you said that we must give by the close of business tomorrow the transcripts.
Just on your and my debate the last time on the power issue.
Yes.
Or lack of power, as you argued. Yeah.
Yes.
Yeah.
Is
Just
it all right
that,
if...
Because, yeah, in the context of you talking about there having been no resistance, as I understood you, by Mr. Carrim, to the possibility of voluntarily agreeing to an assessment. That's the context.
Yes. Is it okay if we mark the transcript?
Yes,
Okay.
please. Yeah.
Thank you.
Thank you to both counsel. Obviously, we can't make a ruling now, and I'm loath to give a deadline by which a ruling will be made. Let me just say, a ruling will be made on a date that will be announced by writing to Mr. Carrim's attorneys and also being publicized in the manner in which our spokesperson ordinarily does. We continue on Monday, 9:30?
9:30 on Monday, yes, Chair.
Yes. Let's adjourn and resume at 9:30 on Monday.